of the Colorado Water Conservation Board. And we'll be hearing about what CWCB is, what they do, and then finally I'll wrap up the morning, hopefully close to noon, maybe a little bit more. Without further ado, I'll turn it over to.
Good morning, commissioners.
Good morning. Good morning.
For the record, my name is Emma Schultz. I'm the second assistant attorney general. I'm in the Parks, Wildlife, and Trustlands unit, which means I represent you all and the Division of Parks and Wildlife, and I practice water law. I have been a practicing water lawyer for 17 years. This is my bread and butter. I do a lot of it in a lot of different ways. And so I'm excited to share a little bit with you. Today we are going to focus on a very high level of water law in Colorado. We aren't going to get into the weeds about different types and different details and different variations of things. I really want to help you understand one real basic point. And so I'll say it a lot of times today, and I'll say it again right now. That is that what you own when you own a water right in Colorado is a right to use water. All of the rules, all of the laws, all of the confusing parts, it all comes down to how we understand and how we manage that right to use. So we're going to talk about what it is that you own when you own water rights. We'll talk about the prior appropriation system generally. We'll talk about beneficial use, what it is and what it means. We'll talk about the different types of water that there are in Colorado. If we have time, we'll talk about the water court case process in a very high level. And hopefully we'll have a little time for questions at the end. I would like to ask if you have questions about something I'm saying as I'm saying it, please interrupt me. I want to help you all understand. As I just said, I've been doing this for 17 years. I learn new things every day. This is not an easy topic. This is not a simple topic. It is not something that with a single presentation you're going to feel, inherently comfortable with or feel like you understand really well. So interrupt me if you have questions. And before I dive in, each of you have been given a set of 4 what look like little magazines. They're called citizen guides. They're created by WECO, the Water Education Colorado. That's a nonprofit organization that does a lot of water education around the state. And they have put together these guides, which are wonderful resources to help people understand water law. We've got a basic water law, transmission diversions, groundwater, and interstate compacts. These also only just barely scratch the surface. But they're wonderful resources. They're great to take home. They're good, bedtime reading. And we'll dive just a tiny bit deeper than I will today. Okay, so getting right into it. What do you own when you own a water right? A water right, let's define that first. A water right is a usufructuary right. That's one of those awesome big legal words. It makes you sound super smart. It's also exactly how we describe water rights. Usufructuary rights are incomplete legal rights. So you have a usufructuary right to use the public's water resource for beneficial use. So let's talk about usufructuary rights in contrast to a non-usufructuary right, a complete right. So when you own real property, when you own land, usually you own the complete legal right to land. You have the complete bundle of sticks. You own the surface. You own what's underneath. You can do anything you want with it. You can let people on. You can keep people off. You can grow stuff. You can kill stuff. You own the air above you and the dirt below you. You own everything in that space. When you own water, you don't own drops of water. You don't own any particular drops of water at all. You own a right to use water. The water itself is owned by the state of Colorado. It's owned by the people and it's reserved for the people to use. So you own a right to use, but not a complete right. It's not a right to hold on to it forever. You can't just take it out of the stream and put it in a bottle and save that bottle for an eternity. I mean, you could if you wanted to, but that doesn't gain you any benefit. The benefit comes from using water, right? Water is meant to be used. Water is only useful when it is used. So you own a right to use water for that beneficial use. So there's a few key components to this. First of all, water is a public good, right? It is owned by the people. It is for the people. We all share it, period. Water is also scarce, and that has driven the system that we use in Colorado. There is not an endless supply of water, although there kind of is an endless supply of water, right? It keeps coming back and there's still more, but there's never quite enough for everything we want and need to do with it. And so because there's not enough and it belongs to the people, it's very closely administered. And we'll hear from Jason Ullman, the state engineer. His job is to administer the waters of the state of Colorado. We take that very seriously in this state, and the whole point of that tight administration is to make sure that we maximize the public benefit. It is a good for all of the people, and so we have to maximize that good for all of the people. Water right owners, they get to build facilities to divert, extract, move water from the stream or the aquifer where it comes from in nature. You have the right when you own water to move that to where you will use it. And that right is based in the Constitution. And we've talked about this in other contexts, and it'll probably come up again in your tenure. That constitutional right of a water right owner to cross others' lands, to build diversion structures on others' lands, to maintain ditches on others' lands. Those are all rights built into the fact that you own a water right. Because water is scarce, we only have 7 major river basins here, but we need to use the water all over the state. Water rights owners are allowed to do what they need to move that water to where it will be used. We also, as a water right owner, have the right to use this natural stream systems to move water around. This is something that wasn't 100% clear when the state began, and it is now one of the basic tenets of our law that you can use the stream systems to move water around. And water rights, because they are a right, you can buy them and sell them and transfer them and move them around. There are rules around it, but they are not tied in stone to the place that they, the place or the use that you get them from. Okay. So water rights are real property in Colorado. Our law treats it like land, but different. But it's really important to understand these are real property rights. They hold some of that level of permanence and importance, same as dirt does. It just happens to be a real property right that you cannot touch or hold. It's a conceptual real property right. But as a real property right, you have that same idea. There's a bundle of sticks that define your right. And those are things that are unique to water. There are things like priority date, the amount of the water right, types of beneficial use, the location of use, the point of diversion, the water source. Those are all a bit of your bundle of sticks that defines your right, because you can't draw a square around it, right? You can't put a fence around a water right. And so our water right is defined by this bundle of sticks, these characters of our water right. And we've defined those legally in water court. Water court confirms water rights that exist. So water court does not create water rights. The people who use water create those water rights. Water court confirms all of the things that the water user has done and makes those a legal protectable right. What that means is only water court decrees can be administered. the state engineer can't administer a water right that has been created by a person but not confirmed by a court. Water court decrees are used to protect water rights. You can't go to water court and protect your water right if you have not already decreed your water right in water court. So these decrees, they define the full extent and the full the full scope of your water rights. And they do so usually expressly, but also sometimes by implication, right? Sometimes a water court decree includes some information and it's missing other information, but you understand those limits by context. And sometimes they don't, and when they don't, there are problems with the water rights. Because your legal rights, because your bundle of sticks is defined by a court can change it. So we can go to court and we can change things like the type of beneficial use. We can change things like the location of use or the diversion point. We can change pieces of our bundle of sticks so that we can make the best use possible of our water rights. Okay, yes.
And maybe a dumb question, but then in the very beginning of time, how was the first decree or the original decrees created? If the court doesn't create the decree, how does that work for like the first water right in Colorado?
Absolutely. I'm glad you asked. So in Colorado, we use the prior appropriation system, and you might have heard the term riparian system before, and it's the more common system in the United States. A riparian system of water law means that if your property touches or contains water, you have a right to use that water. In Colorado, we use the prior appropriation system, and the prior appropriation system means if you were the first one to get to the water, you have the best right to it. So in Colorado, we have a water line, and the way it all started is the territorial Congress. What's the name of the territorial governing body of Colorado before we were even a state? Said people have been coming here and moving water from the streams to their property in order to irrigate it, and they have invested time and money and effort to make their land functional. And so the first person to sink money into something, the first person to do that has the best right to all the water that they need for their purposes. And then we start building our line from there. But early on in in the Constitution and in the first statutes of the state of Colorado, our public leaders said, this is the concept we're going to build our system on, but we don't trust the government administrators, so we're going to put the responsibility on the court to decide who's lying and who's not about what water they have diverted and what they haven't. And so the early government separated deciding who has water and what the scope of their water rights are from the administrators who open and close the head gates and who settle the disputes between the neighbors. And that started at statehood in Colorado. So when I talk about the prior appropriation system, I like to talk about getting in line, right? The prior appropriation system really is a line. And I've explained it to people before, kind of like the lunch line, right? You race to the lunch line, try and get there as close to the beginning as you can, because the first person in line gets the pick of all the goodies and all the best food. And once they've taken theirs, no one else gets to take that from them, right? And then you sort of filter in from there. Now, there's probably enough for the person at the very end of the line, but maybe not every day. And it's maybe not as much as they wanted, but everyone is in line. So on a day when the cafeteria just didn't make enough hamburgers, then somewhere along the way, people just stop being able to get hamburgers. And that's the way water is in Colorado. When there is naturally not enough water to satisfy everybody's needs, to address the whole line, then the people at the back of the line are the first ones to start to lose out. And we work our way forward in time until we get to the point that the first people are all satisfied. At some point, they meet in the middle, right? Most of the time, or some of the time, they meet very, very close to the front. It depends on where you are in the state and what's happening at that moment in time. In the beginning of August, in the driest parts of our state, maybe even the very first person in line isn't getting enough water, but no one else gets to take any until that very first person gets their fill. So the prior appropriation really is about the first person to get there and then the first person to go to court. And the first types of water court cases were very different than what we see today. Those ones were based on people making claims, so filing claims with the then state engineer and saying, this is the ditch I've built, here's my map of it, here's how big it is, how much water I'm using, and this is where my irrigated land is. And then somebody would start a court process, and there were no water courts in the in the late 1800s. There were just courts. And so someone would go to court, and then there would be what was called a general adjudication. It would open up to every water user in that basin. They would all come in and they would tell the court, this is when I started digging my ditch. This is when I started digging my ditch. This is where I am. And the court would put everyone in order from 1 to however many and enter a decree. And that defined those first water rights. We have expanded from those times. And as water court evolved, we really dug into what does it mean to appropriate a water right. And the courts have said that appropriating a water right means forming the intent to appropriate and taking a first step. And that first step has to evidence your intent to the world around you. Not necessarily the whole state, but your whole neighbor waterhood. So first you have to form this intent and prove that you're really gonna do this. And then to really finalize your water right, you have to divert the water and you have to put it to beneficial use. And those two sets of things, appropriation, the intent to appropriate, and diverting and placing to beneficial use. You have to accomplish all of those before you can actually show that you have a water right. After we really did adjudicate most of the water of the state, and that took 100 years-ish, right? After that was done, then people started getting creative. And so we had developed this system focused on just adjudicating the water rights, just figuring out who is in line and where in line do they belong. And then we started to evolve because the new people kept coming and new uses kept coming and there were more needs, but not as much water. And so we started to get creative and the General Assembly stepped in and started adding to and clarifying our laws. We started being able to change water rights. We clarified what types of uses were allowed, and our system has built from there. And our system really is a separated powers type of system. We have our courts that tell us what the rights are and what the limits are, and we have our administrator, the division engineer, the state engineer, who actually enforces all of those rights on the ground. And then today things get even more complicated, right? So early on it seemed like it was easy, and now we have so many uses, we have so many water rights, we have so many needs that we have a lot of work to do. But one of the most important things about water is because it is a right to use, you have to continue to use it, or else it might be reduced or it might be abandoned according to the law because it is a public resource, a scarce public resource. If you're not making use of it, someone else will be. So the system allows for letting go of water rights in a way, or forcing people to continue to actually maximize their uses. Okay, so let's talk about the types of water rights. Now, I said this is the most basic of levels. We have many variations. But when it really comes down to it, there are two core types of water rights. There are absolute water rights and there are conditional water rights. Absolute water rights are water rights where the structures are constructed, water has been diverted, water has been beneficially used, and the court has confirmed all of those pieces. It's an absolute water right. There is no question. We're not wondering whether this is going to happen. It has happened. It's been proven to a court. It exists. It is solid and it's stable. Then we have conditional water rights. And conditional water rights hold your place in line, right? They say, I'm not hungry right now, or I don't have the money just yet, but I'm going to stand right here in line and I'm going to keep this place as the world around me continues to inch forward and maybe people behind me get to use, but I'm still in this place in line for when I'm ready for my use.
So how long can you keep a right and have it be conditional?
A really long time. You can keep a conditional water right for a very long time, but there are caveats. So to get a conditional water right, you have to go to court and establish your intent to appropriate, and you have to provide notice of that intent. Today, that's usually done through the actual water court process, right? We filed our application, we're explaining to the court and the rest of the community what our plan is for this water right. We have taken the first step towards appropriation, which is we have shown our intent publicly. It's not just in my head anymore, but we have done something public and we have some plan. And we have proven that we can and will place the water to beneficial use in a reasonable time. And so once you've proven that once, the court says, okay, I'm going to take your word for it for now, but you have to come back every 6 years and prove this to me again. Show us every 6 years that you still can and will develop this water right in a reasonable time. And the further you get away from that first decree, right, the harder it is to show that the reasonable time piece of your water right is reasonable, right? If it's been 40 years since my initial decree when I got this conditional water right, I better have a really good explanation about why I haven't constructed the structures, why I haven't diverted this water yet, why I haven't been able to place it to beneficial use. For the most part, it's not particularly difficult to show that you have been diligent. That's what it's called. Those are diligence filings, that you've been diligent in prosecuting and developing your water right. However, there are always exceptions. So if our water right is for, say, a gigantic new reservoir, the kind of reservoir it takes 20 years to get permitted through the Corps of Engineers and costs, $8 billion to build, and requires acquiring land from 55 different landowners and as long as you are taking steps in that direction, planning, engineering, talking to the Corps, trying to get a permit, trying to get property ownership, as long as you are moving in the right way. If it takes 50 years, if it takes 100 years, that's okay with the court and that's okay under the system. If you have a water right for an irrigation ditch to divert 1 CFS and it's going to irrigate 50 acres and you've got those acres and you've left them fallow and you've done absolutely nothing whatsoever to start to plan or build the ditch on your property, at some point the court or the division engineer or an opposer, another party who has interest in water, is going to come into one of your diligence cases and say, it doesn't look like you have a plan. This isn't reasonable. It's been 50 years to build a really small ditch that shouldn't cost that much money and there's no permitting barriers. Why isn't this done yet? And you might have the court saying, you know what, that person's right. This isn't reasonable anymore. We're going to let this water right go. It's not super common, but it happens. But you can hold on to a conditional water right for a really, really long time. Conditional water rights, just like absolute rights, can be changed. And that's one of those layers of complication and confusion I'm not gonna dive into very much. I just wanna let you know, just because you've shown an intent to appropriate and all of the pieces for one particular water right doesn't mean that you're locked into that only. You can change conditional water rights, you can change points of diversion, you can change their planned uses, you can change things because plans change and the world changes. You can go to court and you can change conditional water rights just like you can change absolute water rights. So for all intents and purposes, you can treat conditional water rights and absolute water rights legally fairly the same. The difference being one has actual wet water use and the other one does not yet. Oh, and the other thing you have to do when you are, when you're claiming a conditional water right is prove that the claim is not speculative, and we'll talk a little bit about speculation in a minute. But before we get to speculation, let's talk about beneficial use. Because the system in Colorado is built on a right to use, your beneficial use is really the true measure of your water right. Beneficial use defines all of the limits of a water right. So, there we go. So beneficial use includes the type of use, and types of use are, there's a lot of them. Right? Historically and traditionally, there were a few that made sense. And so those really early 1800 decrees, you'll see them focused on 3 or 4 types of use: irrigation, domestic, municipal, manufacturing, industrial, mining, milling, hydroelectric. Those types of uses, we're all familiar with them. We know what these things are. Then there's statutory uses. There are things that might not have been considered a traditional type of use that our elected officials have decided should be a beneficial use in Colorado. And those are things like firefighting, recreation, fishery, in-stream flow, wildlife.
Snowmaking,
I'm sorry?
snowmaking.
Snowmaking. That one's actually not, that's just a regular use. I don't think it's statutory. The difference between statutory uses and traditional uses is that statutory uses are inherently harder to measure. So
What is in-stream flow?
I will tell you, in-stream flow is it's an environmental use, but it has to be appropriated by the Colorado Water Conservation Board. And so the Colorado Water Conservation Board, through their statutory process, studies streams with the help of partners and other agencies, and they determine whether a stream is imperiled or has it would benefit from what's called a minimum flow. So an in-stream flow is a minimum flow right that belongs to the environment, essentially. And so they go through a very long process, but the point of it is to say this stream, to stay healthy, to benefit the fish and the ecosystem here, this little stream needs this much flow at this times of year, at the bare minimum. It just really shouldn't ever fall below that. Well, because our system is focused on the first person to use, that use for the environment, that still has to get in line. And so the CWCB goes through their process, decides what that minimum amount is, and then goes to court to put the environment in line with the rest of the water uses in Colorado. And so what that means is anyone senior to the in-stream flow right can take their water anytime they're allowed to. But if there is only enough water for those prior uses and the minimum flow, no one else gets to take water behind. So it really is it's a water right that protects the environment.
I knew what it was in concept. I did not know how it fit.
Yeah, it actually fits into the priority system. Because by the time it became a thing statutorily, there had already been 100 years of water rights being developed. And in Colorado, we protect the first use.
CWCB then is the holder, the legal holder of the in-stream flow right,
Correct.
whether it's buying it or
Right,
How-
so
whatever.
they're the only ones allowed to appropriate those water rights. And so in talking about what's not a beneficial use, in-stream flow claims
Mm.
by anyone other than the CWCB is not a beneficial
I
use.
wondered about that. Okay.
They work hard to protect that and and we'll hear from CWCB. I don't know that Lauren will talk much about the in-stream flow program because they're the
I think
policy.
the legislature has tried to insert themselves in that question.
The legislature and water users, and it comes up on a semi-regular basis. But yes,
Can a senior like irrigation right be transferred to an in-stream flow rate?
yes. There again, there are limits and there are ways and there are rules. There are whole processes where senior rights can be donated to in-stream flow, can be temporarily used for in-stream flow, can be converted to in-stream flow. All of that we work with our partners at CWCB to figure out and to decide if it's best for the water user, the environment, the system. They have a lot of big processes around that, and they're definitely a partner that we work with.
Emma, on statutory uses where it shows recreational, have they defined that? I mean, does rafting come under that?
No, they have not defined it. What they have defined is, so generally in order to show that a water right has been diverted, it actually has to be taken out of the stream. But rafting is a great example, right? Rafting occurs in the stream.
Right.
And so there is a statutory water right called a recreational in-channel diversion, and there's lots of rules around it. But what that water right is a way to protect a stretch of stream specifically for recreation that occurs in that stream when the stream is at certain levels. And that's the only way you can get a protected stretch of stream solely for recreation. And again, it's going to fall into line. Other recreation is recognized, but because recreation on its own doesn't have objective limits, it's generally not the only beneficial use tied to a water right. For example, lots and lots and lots of reservoirs, the water rights that are in those reservoirs include recreation. Now, recreation in and of itself is not the only type of use that that water is put to, but it is another type of use that it can be put to, because you just can't quantify how much water it takes to enjoy. I mean, you can say it's got to be more than inches so the boat will float, right? But is it 100 acre feet that you need to have an enjoyable recreational experience, or is it 1,000? And because you can't quantify that, you can't have that as the only measure. And so that's where we limit beneficial, that's where beneficial use limits your water right. If you can't measure it, if you can't have an objective limit on the type of use, standing on its own, it's not going to be a quote unquote beneficial use in Colorado. So aesthetic is another one of those, right? Aesthetic is by definition subjective, not objective, right? I may find a flowing river with 5 CFS beautiful. You may say it requires 10 CFS to be beautiful, right? We have different opinions. It can't really be measured. The other thing to note is that uses by nature generally are not considered beneficial uses, which is where that wildlife was named statutorily as a beneficial use. Because usually, right, the animals exist and they're going to drink water. They need it to survive. We don't quantify that. We don't make it happen. It just happens. That is life. We don't take all of the plants off of the stream banks, but the plants drink water, right? So those natural uses, that they're not beneficial use. They're not something that someone can come in and claim as a use that they have made of water. And beneficial use limits the amount of use. When you talk about the type of use, the limit of it, the amount is limited to the reasonable and appropriate amount of water for that type of use under reasonably efficient practices that you can accomplish without waste. So thinking about, say, irrigation, right? The beneficial use of irrigation is limited in amount to the amount it takes to irrigate that parcel using efficient practices and not wasting. Could you put 3 times as much water on an irrigated parcel as the plants need? Sure. Is that a good idea? Probably not. Not for your plants and not for the water system. And so you aren't protected to take that much water. You're protected enough to take enough water to efficiently irrigate the plants. Now, this doesn't mean that you have to go and change all flood irrigation to drip irrigation. Drip irrigation is certainly more efficient. It means for the practice that you've claimed. So if you have claimed flood irrigation, your water right is limited to the amount it takes to flood irrigate that parcel. You don't have to make it the most efficient, the most scientifically advanced use there is.
So quick question on that. So I think, or would it be true that if you have been decreed irrigation water right of a certain amount, you're converting to drip? There's water that isn't used. You would go to court to get that quantified and the beneficial use adjusted, and then it becomes an asset you can trade.
Right. With a lot of limits, but yes.
Yeah.
And when you make that change, right, what you've quantified is the fully consumptive use of your beneficial use. Okay, so let's talk briefly about 2 really important legal doctrines. I've mentioned them both already. We've got the Canon-Will doctrine and anti-speculation. The Canon-Will doctrine says that you will divert, store, and beneficially use water within a reasonable time. It requires you to have a specific plan and intent to complete the appropriation and to decide whether or not you can and will do this in appropriating a water right or changing a water right. The court looks at a variety of legal factors. Now, these are not black and white things. This is a balancing test. You don't have to prove every single one every single time. But the court looks at things like the legal and physical availability of water, the technical and economic feasibility of your project, the present or prospective right to acquire the property necessary to accomplish your project, the ability to obtain necessary permits. These are all things we have fought about in court as water lawyers. These are all things we talk about and think about. But they're not, there are lots of exceptions and lots of ways around it. The idea is, how do we decide when someone says, I am going to build this reservoir, I promise I'm going to build the reservoir. What does it take for them to prove that to us? So Canon-Will is fairly important in water court, both in developing conditional water rights and in changing any water right. So you have to prove Canon-Will when you develop, when you have diligence, and when you change a water right. Anti-speculation is similar, and this matters especially when you appropriate water rights, but it also applies when you change water rights. And this is important for the land board. The anti-speculation doctrine says that it's not okay in Colorado to acquire water rights solely for the purpose of selling them. And so, right, think back to the Rockefeller times when natural resources were being gobbled up by very wealthy people and then hoarded until they could make an ungodly profit on them. Water was no different, particularly in a place like Colorado where it's so scarce. And because it is a public good and a public resource, our leaders, our General Assembly and legislators said, yeah, we can't have the Rockefellers of the world or whoever, right? The billionaires of the world coming in here and essentially owning Colorado's water to the detriment of our people. And so you have to have your own intent to place water to a beneficial use. Yes.
So you can't speculate on establishing the right, but there is certainly speculation in, say, Mesa County of hedge funds buying up land to then trade the water in the future. So it's sort of a form of speculation after the fact, isn't it?
Yes. And it's it is a bone of contention in Colorado right now. Last year, there was an effort to start a change in the statute to prohibit that. It failed because it was a little bit, it was not well thought out or put together, right? But there is a lot of concern among the water community about the hedge funds and the investors buying up farms and drying them up to take the water somewhere else and selling it for a lot more money.
And I guess following that question, some water is pertinent to the land, some isn't, right? And is that, when you're establishing your original water right, why would you ever make it a pertinent? Why wouldn't you make it free of the land? You know, like in the Arkansas Valley, I know there's a lot of kind of loose water, you can move it around. But some water, like on my ranch, is a pertinent. I can't, trade it. So I'm just curious, what determines the appurtenance?
The appropriator.
Okay,
So, for example, I'm guessing, do you have shares from a
no,
beach?
it's just a CFS.
Okay. I mean, I would be interested to see why or how yours is tied to your land, because most often it is not. Now, it is defined by the use of your land, and your land may not be productive or valuable without the water. And so those things can tie water together, but the appropriator is really the one that says, I'm appropriating this water right for this land and this land only, and I never want them to be separated. And you can do that legally, just like you can put restrictions on your use of property legally. And there are reasons why people would want to do it, to prevent things like another Dust Bowl in the Arkansas Valley, or for the benefit of the environment, or to protect a ranging legacy, or, right? There are reasons people want to do that, but they're all individual and personal.
Yeah, this was a very 1890 appropriation, so who knows why it was done.
Right? I mean, your water lawyer could figure it out.
Yeah.
But you'd have to pay for it, I suspect. Yes, Jim.
Along that line that Mr. Harvey raised, are there the concept that we all are familiar with in lay terms, buy and dry? Has the General Assembly in the last 20 years or thereabouts instituted any disincentives or barriers or restrictions on buy and dry?
No.
No,
They've tried. They have tried, and there is a statutory requirement to get, I don't know if it's consent or there's a statutory requirement related to talking to the county if a change of water right is going to dry so many acres in that county. But that's never something I've dealt with, so I don't know all the details about it.
Does that power reside with the county government or solely?
Well, it's a Colorado statute, and it requires some sort of notice and talking to the county when this sort of water court application is filed. But I'm not sure what power the counties have. I just know it's in the statute now. But other
Okay.
than that, every effort to officially limit or apply speculation doctrine requirements on buying or selling water rights in Colorado have failed. And there's a lot of difficult conversations around it, which makes sense why it's failed.
Sure.
Yes.
One more question, slightly different topic. I recall it might be 12, 15 years ago now, there was quite a controversy, I think during the first Hickenlooper term, but may have been into the second, Senate Bill 123, which the General Assembly passed, and then the governor vetoed. Are you familiar with that? And has there been any effort by the General Assembly since that time to pass a concept similar to 123? And if you know all that history, can you explain it to the board?
I don't remember exactly what Senate Bill 123 was about. I remember that something passed and was vetoed. I don't remember the details of that, so I'm not certain I could say whether the effort has been renewed.
Is there
Um,
can I ask if there's anybody on this panel or participating that can give us the history of that controversy?
It's something I can look up, Commissioner
Okay,
Pribble,
sure.
and share with you separately through Nicole.
Good, fine, thank you.
Absolutely.
Never vetoed anything, so that's kind of interesting.
I remember Senate Bill 123. I just don't remember what happened with it.
So I was just gonna mention that one tool that the state has incentivized since 1999 that can be used to tie water rights to the land is conservation easements. And we have among the most generous tax credits in the country. And I think my guess is that's one of the most common ways right now that we're keeping the water rights with the land.
What's interesting is that conservation easements will do things like require irrigation, but may not necessarily actually tie the specific water rights and use at the time to that parcel or to that property. It's a weird roundabout thing. But yes, conservation easements certainly help keep water on the land. Speculation is really focused on that buying for selling, which is a hard thing with the land board because your goal is to earn revenue, right? And so how do we walk this line of making sure that you're doing everything you can to earn revenue, to protect the resource for future generations, to protect the trust, and also not cross over into being viewed like those hedge funds that are pulling water off of the farms in the San Luis Valley to pipe them to Colorado Springs, right? There's a real fine line and interesting balancing act that Justin has to make all the time to manage this. There is a exception for municipalities for water service providers who serve a public. We don't ever fall into that category. Every once in a while, our lessees do. Okay.
So why would you ever separate water from the land?
Water is almost universally more valuable if it is fully quantified so that the amount that you associate with your water right can be fully consumed. And I think Justin will talk about this a little bit, but fully consumable water is simply more valuable than, for example, irrigation water.
Yeah, I found Senate Bill 23 in 2014. It was a authorization of voluntary transfer of water efficiency savings to CWCB for in-stream use. It was a Gail Schwartz bill. And he said it would impact negatively senior water rights.
Oh, so there are lots of ways now in the
Yeah.
statute to loan water to the in-stream flow, to convert water
Yeah.
to in-stream flow. So yes, there have been successful efforts
Yeah.
since then
Yeah,
to
that's what it
allow
was.
that. Okay, I have 4 minutes left, and so I'm gonna blow through this particular slide or this particular topic and then pause without getting into water court because I want to make sure that I respect Jason Ullman's time. He's our state engineer, and I know he's like juggling two things here. So I'm going to touch on this really briefly. There are really two main types of water in Colorado. There is surface water and there is groundwater. Surface water is the water that flows on the surface of the earth. It's usually in defined channels. It can also be in lakes. It can also be in the form of water that has flowed out of springs. We are talking about the water on top of the ground and the water that falls from the sky onto the ground. That is surface water. Then there is groundwater. There are two types of groundwater. We've got tributary groundwater, which is water that's held below the surface of the earth, so under the dirt under your feet. And it is held in aquifers that are physically connected to surface streams. Now, all groundwater in Colorado is considered to be tributary unless it's legally not. I'll get to that in a second. So, when you sink a well, you can assume always that you are sinking a well into tributary groundwater. Now, why is it important to have a difference between tributary groundwater and surface water? It's because tributary groundwater is in the same priority line as surface water. So every ditch in the system is also in the same line as every well in the system. Okay, they are integrated, they are considered to be one and the same. So when you're taking water out of a well, you're technically taking it from the stream. You're just taking it from the stream at a different time, right? You're taking it from the stream before it gets to the stream. And that's really important because that defines that relationship is a part of why we have so many convoluted and confusing interactions, things like augmentation plans and delayed depletions and lots of different conversations that are far more in-depth than we have time for today. Then we have non-tributary groundwater. And so this is also water that's held beneath the surface of the earth. It's held in other way. It's held in aquifers, but those aquifers are not physically or legally connected to the surface streams. So we have three types of aquifers. We have aquifers that are physically connected to the stream, tributary aquifers. We have aquifers that are physically not connected to the stream, like the Denver Basin. And then we have aquifers that may be physically connected to the stream, but there's such a tenuous physical connection that the General Assembly has said those waters are not legally connected to the stream. And we have some fun names for these things like designated basins and not non-tributary water rights and tributary and non-tributary, right? We have lots of words, you'll hear them around. The key is that the law considers some groundwater physically disconnected from the surface stream, which means physically separate from the prior appropriation system. Non-tributary water follows a different set of rules in Colorado. We're not going to talk about those because I could spend a day on those. Okay, it's 8:59. I'm going to pause my presentation here. I promise I'll teach you guys about water court process. But we're not going to do that today. The other things that we can talk about, and I'm happy to come back another time, are things like what are Trans Mountain water rights, exempt type use wells, springs, free river, augmentation plans. There's lots and lots and lots of details. And as you can see, it's really hard to get even through an overview in a real short period of time. But if you have questions when these things come before you with related to decision points, I am always happy to come back to let's lay the groundwork first and then have you use that to help you make the decisions you need to make. I will stick around all day, so I'm happy to chat also during breaks or afterwards.
One last question, if I may.
Yes.
I don't know if you can see this. It's Water Law 101, or maybe you'd call it
In a nutshell.
In a Nutshell by David Getches, but it was published in 1997, so current through 1996. Is it, and it's kind of my go-to reference by our dear friend David Getches, who I know Josie knows really well as well. So the question is there an update to this reference, or is this largely still relevant?
There is no update to David Getch's book, as far as I know, and it is outdated. A lot of the basics in there are still accurate, but the law has changed significantly and developed a lot since 1996. And if you would like recommendations for a good basic reference book that's more than like the Citizens Guides, I am more than happy to send those over to you all through Nicole.
Yeah, I'm sure the citizens, I'm not an attorney, so I'm not, I need a layperson's guide, although I found this eminently readable and understandable.
Yeah, I've read it too. It's very, very good. And there are a couple of other books that are geared toward a layperson's reading or understanding of water law, but that are updated.
Okay, if you could send the reference or the link or whatever, the titles of those books, that'd be helpful.
I'd be happy to.
And
Thank you.
and your presentation too is a great grounding. The
Yeah.
slides are terrific and yeah, thank you so much for the
Yeah,
presentation.
I assume you'll send the slides.
Yes, we are happy to do that. And I am going to hand it over to State Engineer Jason Ullman. Jason, thanks for being here today.
Thank you very
Thanks.
much.
Thank you, Emma.
Muted. Jason, you're muted.
Sorry about that. I was saying thank you to Emma and to the State Land Board and particularly to Justin for inviting me to talk today. I have to apologize for not being there in person. I had originally intended on being there in person, but as we had a change in our division engineer position, which I will be explaining what division engineer is here shortly in Glenwood, and so we moved our fall meeting, which we have fall meetings in each of our divisions every year, to today, and I didn't recognize the conflict until it was too late. So anyway, I'm glad to be here at least virtually with you. I fear that I may not slow down the fire hose that Emma I know has probably, I saw the last 10 minutes of her presentation. So please feel free to ask questions as I go through my presentation that I will tee up here in a sec. Okay, can everybody see my slides?
Yes.
Okay, good. And they're big enough that it's hard for me to tell here. But so Emma has I'm sure done a great job. I didn't hear the whole presentation on giving you a primer on Colorado Water Law 101. The corollary to that is what I'm going to try to do today is explain how is water administered. So how do we administer the prior appropriation system here in Colorado? And that is primarily the responsibility of the Division of Water Resources, who I lead as the state engineer and director. So my name is Jason Ullman. I was appointed state engineer March of last year. So I've been state engineer for about 18 months. And previous to that, I was the deputy state engineer for 3 years, and previous to that, I was the assistant division engineer in our Gunnison Basin office for 11. So I have 15 years of experience with the division, doing anything from on-the-ground administration to dam safety and other things. So I'm going to try to give you as high level of an overview on how we administer water in Colorado as I can. So please ask questions if you have them as we go along. So the Department of Natural Resources includes all of these different divisions, and we are there up in the upper left, water resources. I believe Lauren Riss is going to be talking to you later from the Colorado Water Conservation Board. And obviously State Land Board is included under the Department of Natural Resources. But in terms of water management, I guess the basic explanation is the Division of Water Resources has been around for a long time, since actually 1879 when the first water commissioners were appointed. And its primary role is to administer the prior appropriation doctrine. So enforcing the rules and laws around the prior appropriation system. Water Conservation Board is primarily policy, funding, and that kind of stuff for the state, doing the water plan and such. And it's easy to I think it's easier to explain what we do by starting with the history of why our division exists. And so, as all of you know, the Colorado became a state in 1876. In the Constitution, as Emma probably explained, in Article 16, the state legislature approved or basically dedicated the state as a prior appropriation state. They dedicated the water of the state to the public to be appropriated using the prior appropriation doctrine. So that's now your legal framework. But 3 years later in 1879, this first Adjudication Act created the first water commissioner positions and 10 water districts. And the reason there was some discussion about what entity was going to enforce this new framework back in 1876 and prior to that, but they hadn't dedicated that to or created an office to do that. So they created the water commissioner positions in 1879. The General Assembly then created the state engineer position in 1881 to oversee the water commissioner positions. And there's some other things that happened in those adjudication acts, and then in 1887, they created the irrigation superintendent, otherwise known now as the division engineer. So by, a short time after, within 11 years after the state became a state, we had pretty much the framework of how we administer water here in the state of Colorado using the water commissioner's, state engineer's office, and the division offices. Fast forward to the Water Rights Determination Act in 1969, which I'm also sure Emma explained, and I'm not going to get into details of, but that then set up even a more, put more detail to the framework of the water administration scheme in Colorado that includes these different positions and our office. And this is the primary statute that we refer to when we talk about the state engineer and the division engineer's authority to administer, distribute, and regulate the waters of the state in accordance with the Constitution. And the other, important thing there is that no other official board, commission, department, or agency has jurisdiction over such things. This is a difficult task because we are also charged in that administration with meeting our compact obligations. And so we oftentimes are balancing the need to prevent injury to in-state water uses, the need to meet compact obligations to downstream states, and the need to maximize beneficial use, because there's also a doctrine of maximum utilization in Colorado. So it's somewhat a difficult balancing act between those different charges. So this is a test that works a lot better in person, but I was going to ask if anybody in the room knows how many divisions DWR is broken into. It probably is better if I just go to the next slide and tell you it's 7 water divisions in the state of Colorado, corresponding to the main river basins in the state. How many water districts are in Colorado? So there are 78 water districts. Those have increased, as I mentioned, in 1879, that the legislature created the first 10. So we now have 68 more since that time.
We all knew that, Jason.
What's that?
We all knew that already.
Oh, you did? Okay, good. Justin, I probably should have let Justin answer. So this is a map of river basins in Colorado, and I put this up to compare with then the map of the divisions that'll come next. But you'll see that when I put up the division map that there's mostly contiguous. So the Arkansas, the South Platte, and Republican are divisions 1 and 2. But then you have the Gunnison, which flows into the Colorado, and you've got the San Juan River, which includes the Dolores, the San Juan River, the McElmo Creek, La Plata, that all flow off into the southwestern of this part of the state. Those river basins are split between Division 4 and 5. So that's a map of the divisions. Interestingly, each of these divisions has a division office that's in statute, has to be in these specific towns. So in Division 1, we have an office in Greeley. Division 2, the Arkansas, we have an office in Pueblo. Division 3 in Alamosa, which is the Rio Grande. Division 4, the Gunnison River and the San Miguel and the Lower Dolores. Office in Montrose. 5, we have an office in Glenwood Springs, which is the main stem of the Colorado, which is where I'm at today, is our Division 5 office. In Division 6, that is actually the Yampa White and Green. The Green River comes in from Utah, but then also includes the North Platte, which So this is the only division that crosses the Continental Divide, interestingly. And then in 7, all of those streams that flow south out of the state, and then the upper Dolores as well. So when you drill down to districts, so this is the 78 districts, you see that each of these divisions is broken up by districts, and those districts generally conform to boundaries of streams, basins, because water commissioners are typically designated to districts. So we'll have a lead commissioner and a deputy, sometimes just a lead. But for instance, here along the Front Range, you see, the Poudre all the way down to Clear Creek in separate districts here. So that's how we're organized. It kind of makes sense. You would organize an agency charged with administering the prior appropriation doctrine by hydrologic basin. So our mission, and this mission statement is on our website, but we administer the waters of the state to maximize lawful beneficial use while ensuring Colorado complies with its responsibilities under our interstate compacts and ensures the dams and water wells are properly constructed and safe and provide information about water resources to the public. So I'm going to talk to you all about the first charge there. I'm not going to talk about our dam safety program or our well inspection program, but those are other portions of what we do. But I'm going to talk about the prior appropriation administration and compact obligations. So that mission, in order to accomplish that mission, these are responsibilities that we have. And so under that Water Administration Act, we have these sub things that we do. We participate in all water court cases as a consultant. We have a program to measure streams and diversions called our hydrography program. So we employ a number of people that their job is to maintain stream gauges and to measure streams. So if you've been to our website and you've looked at our stations platform, you can see both our gauges and the USGS gauges and some other partner entities like Northern Colorado Water Conservancy District all in one place. And that's so that we have a one-stop shop to administer the river, because it's really hard to do without measurement. We permit all groundwater wells. We also perform administrative approvals like substitute water supply plans, interruptible water supply agreements, and exchanges, which if Emma didn't get into those things with you, she sounds like she may do another presentation on additional water law components. And then interstate compact compliance is kind of, I consider that part of our administration, because administration is really the act of us directing water use in the state so that we meet these obligations and prevent injury to water rights. So how many compacts does Colorado have with surrounding states? Maybe I'll pause and see if somebody can answer that.
Justin?
Yeah, right. It's cheap.
5.
So we actually have 9. We have the most compacts of any state in the union with surrounding states regarding water. We also have 2 Supreme Court decrees on the North Platte and the Laramie, and we have a couple of other agreements on some smaller creeks. And so because we're a headwaters state, we are blessed with being that. We're the upstream state. We're where a lot of the source of supply is from. But it also means that we have a lot of downstream states that rely in some way upon water that originates in Colorado's mountains, which means we're involved in all these compacts, which means we're involved in sometimes involved in disputes under these compacts. So these are just a list of the compacts. I think maybe without going through the list, if you just look at the map there, you'll see all of the basins that originate in Colorado and where they go across the western United States is pretty impressive. So Colorado on average sends 13 million acre feet of water out of state every year. That's after we make use of the water here in Colorado. Approximately 13 million acre feet leave the state on average. So giving you kind of a high level overview of the geography now, let's talk about those positions. So in 1879, I mentioned that the General Assembly created the Water Commissioner position. So what do? they do day-to-day administration. They set the call on the river based on supply and demand, and a call is not a term defined in statute, but it is the term that we use because people are typically calling our office or calling the commissioner to say, my water right is not satisfied today. I need the state of Colorado to go out and administer the river, essentially shut down water use above me to bring water down to my senior right and satisfy my right, which is what we would term as the call. So they also assure diversions in priority for decreed use without waste. They make sure diversions are measured because if we're going to go curtail somebody, we need to make sure that it's measured appropriately. As you might imagine, it's not a super welcome sight to see your commissioner there with a lot, with coming to your head gate with an order that says you can't take water. And so we want to make sure we're doing that only when we have the authority and it's necessary. Is involved in all of that, and we're going to talk about this just briefly later, is delivering augmentation water, assessing transit losses and things like that. They have to do that because that's necessary to make sure people get the right amount of water. They operate exchanges so people can release water to the stream above or below them and take water above that location as long as they're replacing it through an exchange. And then, making sure other decree conditions are met. They are also then, one of their other charges is to review accounting and maintain diversion records. So the statutes say that the division engineer's office, through their commissioners, must submit to the state engineer annually records of diversions of water in their divisions and what they were placed to. So we have diversion records all the way back to, the beginning of our office. And you'll see actually behind me here, I'm in the library in our Glenwood office. These books are actually water commissioner diversion record books from a long time ago. All that data is scanned and can be found on our website now, but kind of cool that we have that historic record. How many water rights does DWR administer? It's a lot. And so I'll just put it up here. It's over 170,000 water rights in the state of Colorado. Some of them, some structures have many water rights at one location, some only have one, but it's a challenge, obviously. So I'm going to show this graphically because I like maps. Maps, I think, do a better job of maybe explaining what I'm trying to say here than the sheer number. But so this is the area between Fort Collins, Longmont, and Greeley. So this is in Division 1. This is a map showing the streams, but it does not show any water rights. So if I add surface water diversions, so those are ditches primarily, and springs, and then you add reservoirs to this. So those are reservoirs, can be any structure that's holding water for later use. Then you add wells to that. And so that's, I think a graphical representation of what our office is dealing with when we talk about administering water rights and determining who's in and out of priority and how augmentation plans function. It is a complex system with lots of different rights in lots of different locations. So, now getting to what they do, those water commissioners, how do they set the call and what does that mean? So prior appropriation curtailing junior rights. So if you see on the left, this is a simplified version of a stream with two water rights, with one that's 1910 downstream here and one of 1970 that's upstream. And essentially, this 1910 water rights first on the stream. So if there's 10 CFS that's decreed to this right and there's only 10 CFS in the stream, they're the ones that get the right to use it. Therefore, this water right would be regulated back to meet the downstream needs. So if it's 10, they might be shut off completely. If there's 20 in the stream, they might be shut down to 10. And I'm ignoring all the complications of transit losses and timing in this. And then this is what they're actually out doing, is shutting the head gate or contacting the owners of the head gates to get them to shut it and then locking it to make sure that they cannot open it. When they set the call, they are first determining the supply. So they look at the stream gauges that they use as index gauges on the stream that tell them what the conditions are. If they've been a water commissioner for a number of years, they may know based upon that alone probably where the call's going to end up, right? Because they have done it before. But then they're going to look at the demand for water by water right holders. And so they're going to look back at what the people were diverting the last time they were out on the stream. So that gauge may need to have included those diversions. And then they're going to decide where they're going to start with administration after looking at, are there transit losses they need to account for, or travel times? Is there any exchanges being operated, and is there augmentation or reservoir water being released? So they're looking at all those things to make a determination of what priority they might land on. And to do that, like I said, they're using these stream gauges. This is a stream gauge on the Uncompahgre River, south of Montrose. That is a key index gauge for the Uncompahgre call. And so you see the antenna here is what transmits this to the satellite. But you can see this gauge is Uncompahgre River at Uncompahgre Road Bridge online, real time. It transmits every hour, 15-minute data every hour. And then they're looking at the diversions. So what is each diversion taking? So most of the diversions have something called a flume. Most of them have what's called a partial flume, which is great because I went to CSU and by Ralph Partial at CSU. But some of them there's some different types of structures. But when they go out, they're going to look at the staff gauge on the flume here, and they're going to read the level here will tell them how much water is flowing in that ditch. That's how they're going to determine whether this ditch is taking more or less or just the right amount, what they're decreed. And the conditions that they're reviewing while they look at this supply and demand then is the water right in priority? Obviously, it needs to be in priority. So is there another more senior call downstream? Is the water being used for its decreed purpose? And is it meeting its decreed terms and conditions if there are any? When people call for a water right, they have to be using it for their decreed purpose. You can't have a water right for irrigation and call for it for municipal unless it has both of those uses on it. Is water being applied to beneficial use without waste? So that means, are you making beneficial use of the water without waste? And waste is determined differently depending on what application method you might have. If you're flood irrigating, obviously you're going to return more water to the stream. That's not necessarily waste. That is just part of the irrigation method. Does the structure have a headgate and measuring device? If it doesn't, we typically are not going to honor your call because we can't go upstream and tell the other users we're going to shut off, that we're shutting you off for this right that we don't know really what they're taking. Is the structure taking all the available water? And so this means that there can be different colors of water available at their headgate. So if there's reservoir water being released that's going to someplace further downstream, then that water can bypass the headgate. But if there isn't any other colors of water in the stream and it's just natural flow, they have to take all the available water at their headgate. So they have to dry up the stream and make an efficient diversion of water unless there's a reason, either an in-stream flow down below it or reservoir releases or og water going to some other use that has a legal reason to bypass that structure. And this is a question I think a lot of people ask is why is that? Well, if you imagine the commissioner's job is to go upstream from there and tell other people that they're going to be shut off to satisfy this call, that calling right better be taking all the available water that they have that's available to them at that location. Because otherwise, curtailing these other water rights doesn't make a lot of sense and is going to make them pretty unhappy if we're curtailing their rights to send it down to a non-decreed use. And then, will curtailing juniors provide water to the seniors? So there's some cases where maybe there's 10 miles in between them, and by the time that water gets to them, it might not meet their needs because maybe they don't need it anymore if they're calling in September and the water won't reach them until October. But these are some of those conditions that these commissioners are reviewing before they honor before what we call honor the call. And so it can look like, this, some commissioners and staff up at a head gate turning the wheel. This is actually a trans basin diversion at the top of the Gunnison that goes into the Division 5. It can look like this, a commissioner posting a head gate / pump notice to curtail, stop pumping water on their pump and attaching it to the pump. So here's an example of what I just explained, how this occurs. So this is the Uncompahgre. I'm most familiar with the Uncompahgre because I spent 11 years as the assistant division engineer. So when the commissioner's looking to set the call on this particular stream, the gauge they're going to go to is that gauge I showed you the picture of, the Uncompahgre River at Uncompahgre Road Bridge. They're looking at how much water is and has been in the stream, because that's going to tell them what's available. So it looks like I need to move this one window over so I can see. It looks like it's around 80 CFS at the end of this time period. So let's pretend, there's 80 CFS in the river here, upstream of the call. And so that location where that measure is occurring is down here. The call that was placed is at the Montrose and Delta Canal, or the M&D Canal here. The Uncompahgre River flows north through the Uncompahgre Valley. And so they're going to go to their stream administration sheets or spreadsheets and lists. And we have many different lists like this, but they're ordered by priority. Admin number is a number that we've come up with to correlate all the water rights within the state of Colorado to one date. So they're going to look at this sheet and they're going to say, I have how much water in the system? And actually, I should have said a bigger number because here's the system total. So this is the total. If you add up all the water rights to this priority here at the M&D Canal, this priority for this ditch is 100 CFS. That means the ditch total is 127. The system needs to have 244, 245 CFS in it to satisfy this right fully. So if the system has less than that, they know they're going to be more junior or more senior to that. If it has more than that at that gauge, they know they're going to be, potentially the call will be junior to that. And so they're going to use this list to make a decision on where they're going to start curtailing water rights. And this is, one that I include to break up the charts and language that shows that commissioner work doesn't always happen on, the most convenient time. These individuals are administering reservoir water at night because the reservoir water gets to these head gates in the nighttime. So are there any questions about that administration? Because I'm going to kind of move on to the next topic here. This is, yeah. So this map is a map of critical areas in Colorado. So all of the basins, and what I mean by critical is over appropriated areas. So divisions 1, 2, and 3 are completely over appropriated. There isn't any non-critical areas in those divisions, because if there's not a senior call on the river, there's a compact call on the river. The Colorado basins in divisions 4, 5, 6, and 7 have some areas down closer to the state line and on some tributaries that there's not ever been a call placed, which then we would consider those as non-over appropriated areas. But they're fairly limited, as you see, and becoming more limited as I just designated at the request of the Division 6 engineer, the White River to be over appropriated due to a call from Taylor Reservoir's hydropower unit. So for most of the state, this is a reality. The reality that the commissioners are out administering the river at some portion of the year. So I don't, did Emma get into changes of water rights?
Not in depth.
Okay, well, I'm not going to go in depth either, so that's good. Um, So one of the things that makes this a little more complicated is these changes of water rights, augmentation plans. So an example here is two water rights decreed for irrigation to irrigate these two parcels of land. When they were solely used for irrigation, our commissioners dealt with these two rights. There were return flows back to the stream in these two locations on this river system. And so they could administer this fairly simply. But say this right number one gets changed, and this happens quite frequently. And so they leave some of it in irrigation. So there's still a little bit of return flow here, some water coming to this smaller parcel, but the rest of it's changed to municipal and industrial use. So when that change occurs, when it goes through the water court's going to require them to maintain the return flows. So if you go back to this, there was a much bigger arrow of return flows coming back from this much larger field. So now it's just this small arrow. They have to make that up with return flows here. So they've got an accounting sheet that's going to show how that's being done, that our staff review and make sure that that's occurring. They may have other like augmentation releases made out of a reservoir, for instance, that go down a separate tributary that also needs to be tracked. And so this is where we start getting into, maybe if this happens once on a stream system, not so bad. When it happens hundreds of times on a stream system, you're talking about the system becoming much more complex, much more different pieces and parts and colors of water that need to be tracked. And it just is more difficult for our staff. And so we're struggling with coming up with tools right now to help our staff review these things and make those decisions, quickly, because we haven't received, we don't have a lot more staff than we had 20 years ago. We just have a lot more complicated water rights. And so those changed water rights cannot injuriously affect the owners or persons entitled to use water under vested water right. That is why they have to maintain those return flows. Augmentation plans, which are a little different from a change, is a way for you to, we'll just say for simplification, that if you are trying to supply a subdivision or some other property with a well that would otherwise be out of priority, you're going to get an augmentation plan that provides water back to the stream at the same time that those depletions are hitting the stream from your well pumping. And so they get these aug plans that define when they're going to make releases from storage or when they're going to have what kind of dry up of other lands they're going to do. So there's not use happening on other lands so that they can now make use of water at this new location. And that's where, it does, add complexity to this initial system I showed, because maybe this junior user wants to stay on, because in the previous example, we said that they were going to have their 10 CFS completely shut off. Well, maybe they want to stay on and there's a big reservoir up here that they can buy augmentation water from. So they buy that augmentation water and they release 10 CFS to augment the stream so that the senior user can continue taking their 10 and they can continue taking 10 because they've provided 10 back to the stream. And so they're able to divert their water right at that time. So I'm not going to get into much detail, probably about as much detail as Emma got into on groundwater, but suffice it to say that the 1969 Act recognized fully that water is tributary in the ground to the stream unless proven otherwise or categorized as a different type of water under the law. Because as you see here, if you have a well that no matter how much distance from the stream, if it's in an unconfined or an alluvial aquifer, that aquifer was providing water to the stream. So if you pump that well, you are reducing the amount of water returning to the stream. Therein lies the impact to the actual stream rights. And in Colorado, we've are the furthest advanced in terms of some of our water law. We also have made things very complex. So the different types of groundwater use that we have in Colorado, we have alluvial groundwater that's just along stream systems. It's not limited to these, to divisions 1, 2, and 3, but these are the biggest alluvial aquifers in the state. There are small alluvial aquifers along the river systems in the West Slope, but those river valleys are very narrow, so there's not as big of a storage there. Then you have bedrock aquifers, so you're talking Denver Basin and other designated basins that have bedrock aquifers. We have some fractured granite aquifers in the mountainous areas of the state that some people have used wells to draw water from. And then you have the Ogallala aquifer on the eastern plains, so these northern high plains and southern high plains basins. So this is primarily the Republican River Basin. Those aquifers are connected to the larger Ogallala aquifer that extends from Texas all the way into Nebraska, east of us. And then last but not least, we have this very complicated confined and unconfined aquifer system in the valley, the San Luis Valley. There are 4 layers of confined aquifers below what's called a blue clay layer. And then there's an unconfined aquifer on top of that. And we've developed, users have developed a lot of wells in the valley, thousands of wells that draw water from all of those different layers of aquifer systems. That I'm getting close to the end where you can ask any question you want here. But so Colorado gave authority to the Division of Water Resources to permit wells. This has happened with a few acts I'm going to talk about later. But how did that come about? Well, in the late 1800s and early 1900s, there was no rural electrification. There wasn't a lot of wells. Surface water was more plentiful. And scientists kind of knew there was a connection between the surface and the groundwater, but they weren't administering it that way, kind of like Texas and some other states are still not recognizing the connection between the two. But in the 30s through the 1950s, the groundwater development just skyrocketed as rural electrification occurred and pumping technology became more accessible. And there wasn't any permitting or administration in Colorado at that time. So you had this proliferation of wells in all of these aquifers. And that drove the legislature, the General Assembly, to pass a number of bills. And so in 1953, they actually passed a bill that is no longer really in effect that directed CWCB to do well permitting. In 57, they gave that authority to the state engineer's office, but it wasn't very well defined. And then in 65 and 69 are the 2 acts that really set the system that we have now. So the Groundwater Management Act in 1965 set up the designated basins, set up the Groundwater Commission, which I'm the executive director of by statute. The designated basins and the Groundwater Commission manage designated basin water, which is water in a basin that doesn't have a real significant source of surface water supply, where most of the water being used is from a groundwater aquifer system. And then in 1969, as has probably been mentioned, the Water Rights Determination and Administration Act incorporated tributary pumping into the prior appropriation system. So if you have an alluvial well now that is tributary to the stream, you have to get an OG plan to be able to use that unless you have an exempt well. So that is the end of my discussion about administration. So I would suggest if you have questions about our general duties for administration, that maybe we talk about them now. And then I'm going to just briefly talk about a few things going on that are timely right now around the state, primarily around our interstate compacts.
Commissioners?
Jason, I know in Division 5 where I am, and I guess where you are right now visiting, there's too many structures for the commissioners and the inspectors to get around to. And I'm curious if you're using if there's any online technology that's helping you guys out to monitor what's going on with all the structures.
Are you asking about monitoring water usage or
Yeah,
measuring-
for instance, on our ditches for years, the commissioner would basically just kind of repeat what happened year after year after year because he couldn't get around to all the structures. And right now we're being asked to, fill in the forms ourselves on a spreadsheet every year. And I'm just curious if there's any great new technology that's helping you guys, get around, monitor it with not enough people.
So that's a good question. In some basins where we have, maybe one commissioner for a very large area, have had historically commissioners might make it to their structures once a week or once every other week. They are supposed to make it around to at least check diversions that are occurring because we're required to report those diversions. Well, the division engineers are required to report those diversions to me as the state engineer. So hopefully they are making it there, just not very often. What we've encouraged them to do is to ask users to supply data because it is technically a user's responsibility, and it's better for the user to have a good record of what they've used, both to protect the user from getting included on an abandonment list, or just to protect you from any kind, making sure that we can maximize beneficial use in the state of Colorado. The one technology that really helps with that is a continuous recorder or telemetry. We have some funds that are being used right now to install telemetry on some more large structures that we administer every year, so that a commissioner can actually see what's going on at those structures at any time. But we don't have the funding to do it at all of them. And so there still will be some, maybe asks of the users where we can't make it out there as frequently to submit data to our office. We are going through the measuring rules process. In fact, I have a stakeholder meeting tonight at 5 after our division fall meeting here in Glenwood in Frisco. It's our 5th stakeholder meeting in Division 5 on the rules for measurement that we are promulgating here along the West Slope in general, but in Division 5 is the process we're going through right now. I don't know if that was a long answer to your question. Did I answer your question?
Yeah, basically. I guess the second part of the question is I know the standard of abandonment's 10 years, but it seems to me it's been a little bit vague as to whether the user has to state their intent to abandon or if it's just determined by non-usage.
I mean, that's a good question, and it's somewhat of a legal question, but I mean, there is 10 years of non-use can be presumed as an intent to abandon, but the user can rebut that presumption of abandonment through our office because we are required every 10 years to go through the abandonment process. So you can protest with us before it goes to the court and tell us why you didn't intend to abandon it. Or if it goes to the court, you can protest with the court and go through a court process to show the court why you didn't have an intent to abandon. But the standard is a presumed intent to abandon after 10 years of non-use.
Any other questions? Yes?
You used the term color of water a couple of times. I think I know what you mean, but could you explain that a little bit more?
Yeah, no, that's a good question. What I mean is when it's a term that we use to talk about if you are administering water, let's just pretend at a certain head gate on the river, and there's 120 CFS in the river, but maybe there's a reservoir a few miles upstream that's releasing 20 CFS. So 20 CFS out of the 120 is actually reservoir water. And it might be being released for delivery to somebody past that head gate. And so in that instance, we'd say there were two colors of water in the river. There's natural flow coming from the natural hydrologic process, and then you have 20 CFS of reservoir water that we have to track and send somewhere else.
Mhm. Okay.
So in more complicated situations, you may have, og water, you may have reservoir releases, you may have depletions, exchanges happening. So you end up with multiple colors of water in the stream.
Is that, so that's related to, I know I've heard about people purchasing water downstream and then using it upstream and sort of in a sense, moving their water right upstream in different ways. And so it's the tracking of these different colors of water in the stream to understand, who owns which piece at that point and what it's being sent for.
Yeah, and to prevent injury to those rights, that would occur potentially from such an exchange. What you're describing would be an exchange where somebody, wants to has a desire to use water that would maybe otherwise be out of priority, but they above a reservoir that they may own, and they're going to release water from that reservoir to satisfy the senior down below so that they can take water at that upstream location.
Thank you. So now we do have a little time, do we, Jason, for the
Yeah.
comp?
Yeah, it looks like we have 12 minutes.
Okay.
So I don't know how much people, the board is, members have been paying attention. I'm assuming you've at least heard because it's been in many articles. Probably both the South Platte and the Colorado. So I'm going to talk about the South Platte first. So the South Platte Compact has two components to it, and I'm going to try to be as brief as I can. It has an irrigation season component and it has a non-irrigation season component. It also split the river into two sections. So it split the river. You're looking at the map here. And just for your information, this is actually a landing page that we have created for people to be able to find information. So if you scan the QR code on the screen here, it will take you to this landing page. It's at DNR's website where you can find all of the documents related to the Supreme Court case and the compact itself. But anyway, so it split the river into a lower section and upper section. It then split the year into an irrigation season and a non-irrigation season. During the irrigation season, the compact states that essentially Colorado or Nebraska has a water right for 120 CFS at the state line that's measured at a gauge in Julesburg. And that water right has an 1897 priority date. And that water right would be administered only in the lower section. And so we, in the summertime period, Corey DeAngelis, our division engineer in Division 1, his staff in Water District 64, which is the lower section of the South Platte, are curtailing or shutting off all water users from April 1st to October 15th that have a junior date to 1897 if they don't have replacement. So that's the irrigation season component of the compact, and that's what we do to maintain compliance with the compact with Nebraska. So this compact was signed between the states of Colorado and Nebraska in 1923. In the non-irrigation season, and that's where we start the Supreme Court case discussion, there is a water right for 500 CFS with a 1921 priority. That would be for the Perkins County Canal, as stated in the compact. The compact says that Nebraska desires to build a canal, and if they do so, they can avail themselves of this right. That canal would start southwest of Ovid, as described in the compact, and go approximately 13 to 14 miles in the state of Colorado into the state of Nebraska. If they build that canal, and they begin using water from that canal, they would have a 500 CFS right to be administered on the river from October 15th to April 1st. So the wintertime period. And Nebraska never built the Perkins County Canal. They started it in 1894, well before the compact was signed. And then they negotiated its inclusion in the compact that was signed in 1923. So the compact includes in Article 6 this Perkins County Canal. They did consider it a couple of other times, but never put any real money towards it. And then until 2022, when the governor of Nebraska announced plans and a desire to dedicate resources to building of this canal to protect Nebraska from Colorado's desire to take all the water out of the river, which is not true, but and so they dedicated the legislature in Nebraska dedicated $628 million to the project in 2023 or 2022. Since then, we had been meeting and having some discussions with Nebraska about, what their true goals are here. What are their concerns? And we're surprised on July 16th when they filed a Supreme Court complaint against the state of Colorado, petitioning the Supreme Court to take a case against Colorado. We had a meeting scheduled with them shortly after that, and so this came as a surprise to us to continue these discussions. What does their complaint say? Their complaint says that, or alleges that Colorado has obstructed their ability to build the Perkins County Canal. That is not true. The Colorado has not denied that they have a right in the compact that we signed to build a canal, but they have to build the canal that the compact contemplated that, this is in this contract that they signed. They can't build something different than that and expect Colorado to be able to administer it, which they asked the state engineer, my predecessor, Kevin Ryan, to do back in 2023. They sent a letter to the state of Colorado or to Kevin asking him can you tell your commissioners to go, administer our 500 CFS right on the South Platte? And the answer was, well, you haven't built the canal, so no, we can't do that. So suffice it to say, they have made some claims that they've spent a significant amount of money on design. We haven't seen those designs. They've barely started the permitting process, that haven't really had any meetings on the NEPA permitting process, which would be significant. They also haven't done any condemnation, which the compact allows them to do. There's just some question as to what venue that would happen in, but they haven't moved forward with any of those things. So our response, if you go to this QR code and you look at, read our response, I think it's really well written. So I commend our AG's office worked with us, and drafted that. There's nothing to obstruct. There's nothing for us to obstruct. We haven't denied they can build it. They haven't done anything that we can obstruct. The second complaint was that we've been violating the compact since day one. Colorado's been attempting to take more of the water in the river than they're entitled to. And this complaint is based, I believe, in some way on a misunderstanding of the compact, or maybe a desire that the compact guarantee a flow rate to Nebraska instead of providing them a water right with a certain priority. So our commissioners will tell you, when you have a water right, and Justin was, probably in this position, you administer the river and curtail the water rights that are junior to the senior. And if the river doesn't produce enough to get your senior to the full amount of their water right, they're going to get what we can provide them. And that's what happens with this call. That's what's been happening for over 100 years. There were periods shortly after the compact was signed where there wasn't 120 CFS at the state line, and we were doing our job to administer. And we, for 100 years, worked with Nebraska when they've had questions. And so this is a little bit surprising that they've made this allegation now in association with their desire to build, or their stated desire to build, the Perkins County Canal. And so where are we at? We responded to their complaint on October 15th. They had an opportunity to file a short reply to that. It is currently set for conference with the Supreme Court for Friday, November 14th. So that's 2 days from now. However, what I understand from the AG's office is that they could make a decision on Friday, but it's not terribly likely. They have until June when their session ends. So we're kind of in a waiting game right now for the Supreme Court to make a decision on whether they take the case. And our argument has been that this is not ripe for the Supreme Court to take because we haven't obstructed their ability to build the canal. and they haven't proved harm from the irrigation season administration that Colorado is doing. So suffice it to say, we're in a waiting game on the South Platte. The other one that is going to be in all over the news yesterday evening and into today is the Colorado River. What I want to make clear is that, this is a slide that Becky Mitchell and Amy Ostick have used. That we're not this process that we're talking about that you see in the media post 2026 operations of Lake Powell and Lake Mead is not a renegotiation of the compact. It is a need for the Bureau to have guidelines to run those two big reservoirs before the current guidelines expire in 2026. So when we had the drought in 2002, which has continued to today, but ostensibly it started in 2002, there was a realization as the reservoirs dropped precipitously that they needed to do something and operate the reservoirs differently. So the 7 states got together, they signed this 2007 operating agreement or guidelines that was a 20-year period, which 20 years from 2007 means that in 2006 they expire. And so without guidelines for operations of the reservoir, the Bureau has to make a decision on how they're going to operate, whether they go back to previous operating criteria or not. So the states have been in this for 2 years now, have been in a very heated and intense negotiation on how those reservoirs might be operated to benefit both states, because the current guidelines don't work. We'll just be completely honest. They don't work. They allowed the reservoirs to be drained because they tied the two reservoirs together. And so if you had a lower level in Lake Mead, which is the downstream reservoir, it allowed more water to come out of Powell. Lower level in Lake Mead, you can see how that ratchets down to where we're at today, which is less than 30% of available capacity. We're close to the levels where Powell cannot generate power anymore, which is concerning for the Bureau because they get a lot of their funding for operations and for the recovery program comes from that power generation. And so the 7 states have been meeting. Yesterday was a deadline set by the acting assistant secretary for water and science, Scott Cameron, for the 7 states to come up with some framework of an agreement. And there have been a number of different strategies or methods for operation that have been introduced by both the upper basin states, the lower basin, some of the environmental community. Recently, they've been talking about this natural flow concept, which would ostensibly deliver a certain percentage of the natural flow from Powell downstream. But the problem is the percentage matters greatly. If you have a high percentage, you drain the reservoirs. We in Colorado, New Mexico, Utah, and Wyoming would like to have some water in those reservoirs, Powell primarily, to help us meet compact obligations. So yesterday, you may have seen in some of the newspapers, I think the Colorado Sun, the 7 states released a statement saying that they have made some progress. They weren't there yet. And so they were looking for more time. The Bureau has indicated that they could wait until as late as March to parachute in an alternative. But unfortunately, the state of Arizona chose to the governor made a request to the Trump administration or to Doug Burgum, the Interior Secretary, for them to step in. So there's some unknowns as to where we're going from here on these negotiations. Hopefully, I think that, 6 of the states at least intended to continue negotiating and talking about an alternative. But I don't have any additional information than that. So with that, my last slide is on this Texas v. New Mexico case. And I guess given that I have little time or no time, my only thing I'll say is that this is the good news out of our compacts is that Texas v. New Mexico and Colorado, which is a case filed in 2013, we believe it's finally settled. The special master that the Supreme Court appointed We had a hearing in front of the special master about a month ago where we recommended the entry of a consent decree. And we believe that he will write a report to the Supreme Court recommending the entry of that consent decree, and that the Supreme Court will probably go ahead and sign it at some point after that. So here we are celebrating at the Philadelphia Museum of Art. So this is myself, the Commissioner for Colorado, Liz Anderson, State Engineer for New Mexico, and Bobby Scove, the Governor appointed Commissioner for Texas. So with that, hopefully, if you have an easy or a short question, I can try to answer it before I step off and go to our fall meeting here in Glenwood.
Jason, we really appreciate you taking time out of your meeting to address us and fill in some of these details. The graphics were especially helpful in understanding the complexity of what you all do. Want to thank you on behalf of the board for enlightening us, and I'm sure we'll be in touch through Justin and as things evolve here.
Excellent,
Really
excellent
was.
presentation.
Okay, so I'm leaving you with a quote, if there aren't any questions, that is from the state engineer in 1890. And this quote is hilarious to me because things haven't really changed. People expect that water administration, well, it's prior appropriation, first in time, first in right. It's easy, right? And even back then, before we had all these complicated OG plans, he, had wrote this quote that indicates that there's a lot of uncertainties in managing a natural resource such as water. So, and I will share my slides with Justin so that they can
Awesome.
be available
Thank you.
for you as well.
Great.
Thank you.
So much.
Excellent.
Thank you.
Thank you.
And commissioners, I'm going to recommend a 5-minute break here. Is that agreeable to everybody? Great. And then next up is welcome. So 5 minutes. We'll be back.
Thank you.
Thanks. Are you good? Yeah, me too. How's the drive? Not too bad. Coming in today.
No, I got him last time.
Yeah.
Just wondered one of these things, like, was it wait for
We good?
You won't gonna be on the way.
No, I don't think so. It's fine.
I'll just leave it there.
Yeah.
You should be able to control it now.
Okay, great. And do I just right click to advance it?
It's up to you. Or the keyboard arrows.
Oh,
If you like those.
got it. Okay. Good morning. Thank you for having me. It's always a treat to come talk to other state agencies and commissions and boards. I feel like we are all sort of in the same boat. We understand part of each other's worlds, even if the subject matter is different. So thank you for having me. And I'm lucky to go last because I feel like Emma and Jason talked about all the hard things. So it's nice to back clean up. I am Lauren Riss. I'm the director of the Colorado Water Conservation Board. And I'll talk a little bit about kind of who we are and what we do and the water plan and our funding. But I don't think I have probably a full hour's worth of presentation and slides. So if you have questions, if that's okay, feel free to just interrupt me. So as you know, we are a division in the Department of Natural Resources alongside the State Land Board. Our mission is to conserve, develop, protect, and manage Colorado's water for present and future generations. We are governed by a 15-member governor-appointed board, and that is comprised of representatives from
each of the state's 9 major river basins. I mean, technically there's 8 major river basins, but we carve out a special seat for the Denver metro area because it has its own complicated, unique issues. And then we have 5 ex officio board members as well. The only voting member of our ex officio directors is Dan Gibbs. So we are a geographically based board, not an interest-based board, which I think sets us apart from a lot of other boards and commissions in the state. Our board members each serve up to 2 3-year terms, and they're staggered. So that means we always have a mix of new and experienced folks at the table. And we're especially proud to have our current chair, Director Lorelei Cloud, is our first ever tribal member. And she has brought a really important perspective to our conversations at the board. And now is, of course, the first tribal member to lead it. So as far as what we do, we have several different sections within the CWCB, and we have a staff of about close to 70 people now. We've grown quite a bit over the last few years and have added positions commensurate with increased funding levels, which has been really exciting. But as you can see, those are our primary sections within the agency. We have a water supply planning section that handles all sorts of conservation programs, our water plan, I'll talk more about that, including municipal conservation, agricultural conservation, water efficiency planning, and all sorts of water supply conversations. We have a stream and lake protection section, and that is the home of our in-stream flow program that I understand you talked a little bit about. Emma probably explained that we are the only entity in the state that is legally authorized to hold in-stream flow water rights, and those are water rights that stay in the rivers or the lakes for the benefit of the environment. We also have a federal and interstate section where we support a number of the state's interstate compacts and federal recovery programs. We also have a floodplain management and watershed health program. We designate floodplains around the state and work with the National Floodplain Insurance Program, which is as close as we get to being in any kind of a regulatory role. And then we also have a couple of staff that work primarily on watershed health programming because that is so closely tied to the health of our rivers and streams and water supply. Then, very importantly, we have a finance section and a grants section. And I'm going to talk a little bit more about this at the end, but the finance section in particular is kind of our agency's bread and butter. It's what allows us to be fully self-funded. We don't rely on any general funding in the agency. We operate a revolving loan program where we provide loans to a variety of infrastructure projects around the state of Colorado, and then the interest that we charge on those loans allows us to fund a whole bunch of projects and programs within the
Lauren,
agency.
how did you get the original corpus of the money to be put into the revolving?
Yeah, so for our finance program, we receive 25% of the state's severance tax revenue. So half of that goes to DOLA, half of it goes to DNR, and then of DNR's 50%, we get 25% that is statutorily directed towards financing for water projects. So on any given year, we have about $40 to $50 million available for new water project loans. And then we charge a really low interest rate on those loans. It varies by the market, but it's the lowest you can find for water projects. And we work primarily with ag infrastructure projects, ditches, headgates, but also some storage facilities for municipal water projects as well. So that's where the funding comes from for that. And we also get a small portion of federal mineral lease revenue, but not nearly as much as severance tax. So, really importantly here, we are not a regulatory agency. We can't tell anyone what to do. We don't own or operate water projects. We're not like CDOT, where we have a list of transportation infrastructure projects around the state that we can, prioritize and fund. we operate in much more of a passive capacity where we are responding to the needs of partners around the state and water utilities and ag operations around the state telling us what their needs are, and then we try and find an appropriate funding source for that project. So I'm going to talk a little bit more about the actual grant programs and what our loan program looks like. But what we do in our agency is really kind of the softer side of water policy. So you just heard from Jason Ullman. I like to say they're the water cops. You know, they're the ones that are actually telling people what they can and can't do, going out, shutting off head gates. We are the technical experts. We're the conveners of difficult conversations around the state of Colorado, and we provide a lot of grant and loan funding. So unfortunately for Jason, and he's not online, so I can say this, people tend to like us in the water world and tend to, you know, be a little nervous when Jason comes around. Let's see. Okay, so the other important thing that I need to talk about in order to understand what CWCB is are the basin roundtables. Are you familiar? Is anybody familiar with the basin roundtables? You've been around the world long enough to know about that. So these are really what provides the grassroots, ground up input to our water supply planning process in Colorado. These forums were created through legislation in 2005 called the Water for the 21st Century Act. They were really the brainchild of Russ George, if you're familiar with Russ George, former Speaker of the House and DNR director and transportation CDOT director. He's sort of our grandfather in a lot of ways, and this was his idea to set up stakeholder groups, one for each of the main river basins in Colorado, and have these provide a space for local conversations about water supply. They've grown a lot. They're 20 years old now, but they have really provided kind of the connective tissue and the social infrastructure for how we operate at the CWCB. And they have since grown to play a very important role in the development of the water plan. The other important stakeholder body that we work with is something called the Interbasin Compact Committee, or the IBCC. You may have heard of this as well. This was also in the Water for the 21st Century Act. And the vision was, if you have stakeholder groups working in each basin, the roundtables, then you need some kind of mechanism for those basins to communicate across the state. So the IBCC does not have a formal policy role. They are a sort of a think tank of 2 appointments from each of the 9 basin roundtables. It's a 27-member committee. It's quite large. 6 members are appointed by the governor. And then we also have 1 member appointed each from the House Ag Committee and the Senate Ag Committee. So it brings together voices from around the state of Colorado, including some political appointments. And I think it's fair to say that over the years, because their role is not specified, or they're not given any sort of statutory responsibilities, that there has been an ongoing struggle for how to make the IBCC work effectively, kind of what their role is in this conversation. So it has sort of ebbed and flowed over the last 20 years. This group was very influential, I would say, in putting together the framework for what then became the water plan, providing some sort of guiding principles for how we think about coming up with a strategic plan for water supply in the state. They, after the development of the first water plan, I would say they sort of slipped back into a sort of existential crisis about, what they were meant to do and how they could be most impactful in these conversations, and have since decided to sort of revisit that first framework that they put together and use that to help guide the development of the next water plan update. So I think there's a sense of renewed energy in this group, and kind of a feeling of meaning and importance. So I will say from my perspective and my role, it's very helpful to have the IBCC as a kind of a diffuser of difficult conversations in the state. It's a place where people are not, sitting in front of microphones and being recorded and, making, public statements and kind of on their bully pulpit. It's really been a conversation place where people can come and just have some tricky conversations about water supply. And I think that has helped to diffuse things a bit. So before I go any further into some of the actual programming in the water plan itself, I don't know if you've talked about this with Jason and with Emma, but I like to say really what we struggle with in Colorado boils down to a plumbing problem. We have 80% of our water that falls on the west slope, and we have 90% of the people in the state of Colorado that live on the east slope along the Front Range. And that is why we have difficult conversations in this state. How do we move the water to where the people are? How do we recognize that there are a variety of competing values? Acknowledging that water is important to quality of life and the livelihoods for people on both sides of the divide. And this is where, the roundtables play an important role, and why we ended with a water plan as kind of the guiding light for how we move forward. The other important thing here, and it's funny that Jason and I have the same slide, and I'm not going to repeat what he said. He covered it very well, but you can't talk about kind of the plumbing challenge in Colorado and the sort of values challenge we have without talking about the Colorado River. It's in the news. It supplies water to 40 million people, including our Front Range. I mean, there's no part of the state in Colorado that is not touched by the Colorado River. But I guess what I did want to dive into a little bit deeper is how these conversations are structured in the state of Colorado. So you have Jason Ullman, who's the state engineer. He would be charged with administering water rights with the Colorado Compact. So if there was some situation that were to occur where we needed Jason to curtail some water rights because of the requirements of the Colorado River Compact, he's the one that would be in charge of doing that. At the CWCB, we have a section of lawyers and technical experts that work with the Attorney General's office in providing staff support around the negotiations that Jason was describing. A couple of years ago, the governor created a separate position for the Colorado River Commissioner, Becky Mitchell. That used to be coupled with the CWCB director position. That's how it most recently was structured. But recognizing the importance of these conversations and negotiations coming up, the governor split that off into its own separate position. So now Becky is the Colorado River Commissioner. It's a full-time state position that is housed in the Department of Natural Resources, and she has been the state's lead negotiator alongside other principal negotiators from each of those 7 basin states that Jason described. So the Colorado River is one primary example of how we have really been forced to work across agencies. It's become a really important partnership with Jason's staff at the Division of Water Resources, with the Attorney General's staff, because it is so litigious. And there's, just so many legal agreements and case law that surround how we operate within the Colorado River Basin. So I won't say much more than Jason said. He described kind of the state of play. There was a really important deadline, as he mentioned, just yesterday. Becky and a number of folks in my staff have been in Las Vegas and Phoenix over the past several months in really heated conversations with these other 7 basin states trying to come to an agreement. And as Jason said, the details are limited at this point, but the understanding is that there have been there's been some progress to put together an agreement amongst all the 7 basin states. And it sounds like there's more detail needed to flesh that out, but that we'll likely hear more in the coming days. It's been an interesting tension, just as Jason stated, kind of the relationship between the federal government, the Trump administration, and then state sovereignty, and how that all works together. So more to come on that. So I'm going to pivot now and talk a little bit about the water plan, both the history and the current status, because that has really become the filter through which we do all of our business at the CWCB. So there was a time in the early 2000s where I think there was a sort of an awakening that something in Colorado had to change. In 2002, we saw then what was the largest wildfire in the state of Colorado, the Hayman Fire. Cheeseman Reservoir to the right there reached precipitously low levels. And we really didn't have a good sense of where we were as a state and where we were heading in terms of a strategy for ensuring that we were able to meet our water supply needs of a very much growing state. So in 2015, well, let me back up. I mentioned the Water for the 21st Century Act that was in 2005, the brainchild of Russ George. He developed the Basin Roundtables and the IBCC, and alongside that called for a first ever water supply initiative. It was called the Statewide Water Supply Initiative that was meant to be sort of the technical foundation for what we would do as a state. It was the first time that we looked holistically at what the water supply challenges were, what the gaps were across the different water sectors in Colorado, ag, municipal, energy and recreation and environment, and tried to make some sense out of how that, what the trajectory was for our water supply going forward, facing a growing population in the state of Colorado. Out of that, Governor Hickenlooper in 2015 issued an executive order that the CWCB developed the state's first ever water plan. And at the time, that was met with a lot of skepticism that this was going to be a top-down directive issued by the state for how we were to use and operate water projects and use water supply in the state of Colorado. So we leaned heavily on the Basin Roundtables at that point, and put many, many miles on the road in meeting with those groups of already informed citizens to develop what we called basin implementation plans. So each basin in the state of Colorado developed their own water supply strategic plan, identifying what the challenges were in each of the basins, and then opportunities for how to meet those challenges. And those basin implementation plans were then rolled up into the state water plan. The water plan in 2015 was very information heavy. It was about 400 pages of the history of water in Colorado, describing all of the various underpinnings of that, what the prior appropriation system is, what all of the federal programs were, and then tried to elaborate on the various sectors and the importance of water to the quality of life and values that we have as Coloradans. It was, I think, widely viewed as a non-threatening document. Everyone could see themselves in it. Everyone had a place in the water plan somewhere. We conducted just gobs of public meetings. I think it's been said now that that's the largest stakeholder involvement process to date in Colorado. And I think while it was painful to sit through and to hear hours and hours of public comment at the CWCB board meetings, it really kind of brought everyone together. And because it was so light on action and direction, it became, I think, a very non-threatening water plan. However, we were criticized that it was too light on action, and for being a plan, there wasn't a whole lot of steps that we were going to take, at least that we could really measure and be clear about. So we undertook an update to that water plan in 2023, which was part of the planned process, that every 7 to 10 years we would update the water plan so that it wasn't just a static document. And so we took that criticism to heart, and I think really benefited from the fact that it was no longer considered a controversial political document. We really honed in on it being kind of twofold: an opportunity to partner, recognizing that the state does not own or operate water projects, that we really rely on our partners, both local government, utilities, nonprofits, to actually do the work of water supply planning. And it became a strategy document for the CWCB. We used it to identify actions that we committed to actually doing as a state. So there are 3 parts to the water supply planning process that we're carrying forward into even the next iteration of the water plan. The first, building on this statewide water supply initiative that came out of the 2005 legislation, we now call the technical update to the water plan. This most recent version that the 2023 water plan was built on diverged from the previous analyses, and that it took a scenario planning approach that incorporated climate change models. So it wasn't projecting one hypothetical future. It was saying, depending on the choices that we make within Colorado, there are, a variety of ways that our future could play out. And so it sort of plays with the different levers of demographics and conservation and collaboration and kind of how we determine together we are going to govern our water supply challenges, what local governments choose to do, and then, innovation, how technology helps us adapt or not. And so what you see in this water plan is a range of possible scenarios and futures that correspondingly then have various gaps in water supply challenges. So we could see an up to 700,000 acre foot water supply gap for municipalities. That would be at the extreme end if we have a hot, dry, more populous future in Colorado. Based on the technical update, then we still had basin implementation plans. This update tried to make those a little bit more streamlined so that they were formatted similarly and had, kind of the basic format and framework. We used consultants to help us work with each of the basin roundtables to develop those so that they weren't, completely unrecognizable from each other. And then developed and adopted the updated 2023 water plan that's now, just crazy, 2 years old. So as I said, this water plan is much more action heavy. We divided it up into 50 partner actions that we needed partners to implement, and then 50 agency actions that we committed to doing alongside our sister agencies.
And this might be
Yeah.
a naive question, but was the State Land Board one of those partners?
Yes, and I'd have to look. I have a website I can send you that lists what all of the actions are across the state government. And there are, I believe there are examples or at least mentions of the work that the State Land Board does. And I'd be happy to send that out.
Important in our planning as we.
Absolutely. Yeah, I'd be happy to look through that and even just, highlight the ones where the State Land Board could play a role. So the way we divided up the action areas for both what the agency was going to do and what we asked partners to do was by these 4 categories, which basically boils down to, cities, ag, environment, and planning. So we have vibrant communities, which includes municipalities, utilities, industries, both small communities, rural and urban. Agriculture, of course, is the major user of water in the state. Thriving watersheds, which includes environment and recreation, river health, forest health, and aquatic species. And then resilient planning, which just acknowledges the importance of climate adaptation and continuing to stay on top of, what is actually happening on the ground, to analyze that data, use that data, and develop more of an adaptive planning process going forward in future water plans. The way that we make all of these partner actions happen is really through our funding. I mentioned before just how important our loan program is for the agency. I won't repeat that, but it really is the bread and butter of how we operate. I think pretty uniquely, though, we have to have legislative approval for any loans that are above $10 million. And so we have to go through every legislative session, a pretty omnibus water appropriations bill that's called the Water Projects Bill. Maybe heard of it. It includes millions of dollars worth of project funding, loans over $10 million. And then also that is how we take a lot of the interests that we earn on those loans and funnel those back to grant programs. We have to have that funding appropriated by the legislature. So generally it's a pretty non-political piece of legislation that everyone is excited to vote for because it does provide money to just about every community in Colorado. But every now and again, we get a project on there that is a bit of a lightning rod. In the last couple of years, we had funding for the Shoshone water right acquisition. If paying attention in the news, that is coming up again. Very recently, very currently, it's in the news. We have a hearing on that next week in front of the CWCB board. But there was funding, there was $20 million worth of funding that went towards that water right acquisition. And, you know, that happens every now and again. There'll be some big thing in the water projects bill that makes it political. But for the most part, it's a pretty nonpartisan piece of legislation. Then we also have a variety of grant programs, and I haven't included all of them on here, but those I would say are our main grant programs. I'll talk through those a little bit. So I mentioned our loan program. Those are the types of projects that we fund generally, but we have the most flexibility with the types of projects that we fund through loans. The Water Supply Reserve Fund is a pot of funding that takes a piece of the severance tax revenues that was specifically created as a carrot for the Basin Roundtables. So how do you get people to sit around the table and talk about water challenges in their community? Well, you dedicate a source of funding for them to use towards solving those water problems. We have about $3 million a year that we divvy up across the roundtables, and they recommend projects to be funded from their basin that then are forwarded to our board, and our board has final approval over those. The roundtable input is really important. I can't remember a time where our board has denied a project that has been recommended out of this pot of funding. We also have water plan grants, which has, I think, become our showcase grant program. This receives funding from the tax revenue on sports betting that was legalized in 2019 through Proposition DD. It is statutorily directed to fund only those categories of projects on the slide. Storage and supply, water sharing agreements, conservation and land use, engagement and innovation, agriculture projects, and then watershed health and recreation. Because it was a citizen passed ballot initiative, it is one of our more protected funding sources. The legislature has been known to, we'll say, redivert funding from some of our cash funds. Not that Ms. Scanlon has had anything to do with that, but no. It's tricky. And we sit on a lot of funding from severance tax, and that becomes a very appealing option when we're in a budget crisis. So our water plan grant program, that funding source is more protected because it was a ballot initiative. The revenues for this have grown tremendously over the past few years. When it was first passed in 2019, we were anticipating getting $12 to $15 million a year for water projects, which was great. But then COVID hit, and I think people in Colorado love their sports, and there wasn't a lot to do. And we saw a lot of online sports betting. And as a result, we're looking at projections now in the next couple of years as that caught on, having about $50 million to award water projects, which is amazing. The past couple of years, we've had about $30 million. We have 2 grant rounds a year, and our board just approved a suite of projects at our September board meeting that totaled $30 million, and that was just for one grant round. The demand seems to ebb and flow with the availability of federal funding. So now that the federal funding has been frozen for a lot of previously available sources that people relied on for water projects, they are now flocking to this grant program, which is great, but challenging because, we're once again at capacity. In one grant round, we basically gave out all the funding we have available. But as I said, projections for this are likely to grow in the next few years. I did also want to mention, I guess I don't have a slide for it, a technical federal assistance grant program that we run. We call it TAFC. This is less important now that, as I said, the federal funding has dried up a bit, but it is a grant program that we operate geared directly at helping local communities access federal funding. What we heard a lot from folks, especially a couple of years ago when there was a lot of federal funding through the IRA and the BIL through the federal government, that people knew the funding was out there, but were really having trouble accessing it. So this was a grant program that was meant to fill that capacity void. We granted funding out to entities who wanted to hire their own contractors to help develop grant funding for projects. And also we provided that technical assistance through a contractor that we hired directly through the CWCB that folks could tap into for smaller projects. And it was tremendously successful. We were able to access tens of millions of dollars while they were still providing that funding. So we'll see what happens going forward, but that has been an important piece of the puzzle that we've helped with communities.
Lauren,
Yeah.
Curious, so for the 2023 update, there were two sets of actions, 50 in number. What were some of the most ambitious actions to be taken, and were any of these controversial? The first one was sort of milquetoast, everybody has a love in. This next one had some actions that were specified. What were the most ambitious, and then what were any of the resistance or reactions to those?
Yeah, that's a great question. I would say we're only 2 years in. We did issue a progress report, which has been important for us to show some accountability and transparency about what we're doing. And that's available on our website. So you can see some good examples. But a couple of those that I would mention are, we developed what's called a Wildfire Ready Watershed program, which is a strategic approach to how we fund watershed projects. In our world, that is sort of a bottomless pit of need. There is especially in Colorado, there's just so many federally forested lands that it's a never-ending project. And because fires have increased in intensity and frequency over the past several years, it's become increasingly important. And the connection to water supply there is when we've had big fires around important water infrastructure, reservoirs, or even ditches and water supply mechanisms, that creates a lot of sedimentation. We see a lot of debris flow and then flooding in those burn-scarred areas. And so what this Wildfire Ready Watershed project did, that was an action in the water plan, was aim to take a strategic look across the state of Colorado at where were our biggest, we call them values at risk. So where are these really important infrastructure projects? And they could be just population centers too, communities, but also, storage, water supply projects, municipal treatment facilities. Where are those values throughout the state of Colorado that would be most impacted by a wildfire? So we pulled together collaborative community groups to develop strategies around what we could do to protect those values at risk. So it was a lot of GIS work identifying where those locations were in the state of Colorado, and then community involvement. What can we do to protect those? So now we have roughly 20 wildfire action plans that are these locally driven plans that we then look to fund projects. So if you don't have a project that's in an action plan, then the chances of it getting funding are a little bit diminished, because we want to make sure that the dollars we're putting in to watershed health projects are going to have the biggest bang for the buck. And up until this point, we haven't had a framework for doing that. And so I would say it's been lauded across Colorado and people appreciate, I think, the strategic focus of it. But I would also say it's been a little bit controversial because if you don't have a wildfire action plan and you submit for funding, like I said, it's trickier for us then to fund it because we're trying to be strategic. And so people sometimes get grumpy that we're not funding what they would view as a good project if it's not tied to an action plan. We've also done some work with the ag communities. We released a report just this last year called 10 Strategies to Protect Irrigated Agriculture in Colorado that aim to take a look at the ramifications of buy and dry. Are you familiar with that term? Yes, of course. So aim to take a look at what the ramifications were of that to local economies, to school districts, all the various ways that that plays out in real life when we're taking irrigation away from ag lands. And then looked at some innovative ways that we could, protect that. And they're not necessarily like legislative ideas or things that the CWCB can do alone, but they're I would say, more innovative type ideas that as a state that we can try and move forward to address some of those challenges. So those are two examples, but there are many more. Some of them are not very spicy. They're things that we ought to be doing anyways, helping municipalities develop water efficiency plans and measure those better. We had a big initiative around water loss in Colorado where some of the smaller utilities did not have a good handle on basically where their pipes were leaking. And so we have been putting trainings together around the state of Colorado for how to support utilities actually undertaking that effort so that we can make sure that the water supply we have is actually getting to the end user. And then also we've done a lot of work with land use planning. That used to be, kind of a touchy subject where you didn't bring the water supply planners together with the land use planners. But more and more in Colorado, we're seeing that happen. And so we've tried to facilitate those conversations through workshops and forums. Yeah.
Commissioner Pribble had his hand up first.
Yeah.
For a while.
Commissioner Pribble?
Yeah, two items, Lauren. First, a simple request. Would you make sure we all get a hard copy of the 2023 water plan?
Sure.
And secondly, nature's most prolific dam builder and water conservationist is the beaver. CPW is undertaking the creation of a beaver management plan or some such thing like that. Are you aware of that, and have you cooperated with them at all in terms of the beaver capability to create storage, especially in alpine areas, mountain meadows, etc.?
Yes, thank you, Commissioner Pribble. That's an excellent point. And beavers, shockingly enough, a couple years ago were a very controversial topic at the state legislature. Those of you that were in those conversations around stream restoration efforts, it's variably called nature-based solutions or beaver analogs. It got very complicated with how they were potentially affecting other water right owners. But yes, we are very involved in those conversations, and that's a lot of work that our staff in our watershed health section does. We advise and fund a lot of stream restoration and watershed health projects that look at those nature-based solutions. And that's not only the beavers themselves, but how can we take the good work that beavers do and incorporate some of those more natural principles into our restoration efforts to sort of mimic the work that beavers do in providing floodplains and aquatic habitat that makes our systems healthy. So yes, we're involved and we work closely with our CPW partners.
Good. I would just like to offer to my colleagues, currently there's no limit on beaver harvest or take, either hunting or trapping. Most often, you'll have an agricultural producer, and Mark Harvey maybe is far more knowledgeable about this than I, who, believing that their stream flow is impeded or their irrigation ditch is somehow affected by beaver, will resolve the issue with a rifle, or hire a trapper to come in. I think the plan hopes to create some sort of limit on the harvest to allow this important species to proliferate a little bit more than we have in the recent past, which has been kind of very, very destructive. So I just want to offer that observation.
Thank you, Commissioner Pribble. Commissioner Harvey.
I'm curious what your assumptions are about future snowpack, both volume, seasonality, 30 to 50 years from now, and how you're making those assumptions, which science groups you're using to make them, and what are the contingency plans? A little easy question.
Yeah, no big deal. I mean, I guess I would start by saying, you know, in our world, snowpack is considered the largest storage facility that we have in Colorado. That is how we get our water. I don't have the, you know, actual numbers or data in front of me, but I'd be happy to provide that. It's in our technical update for the water plan. We do a lot of modeling around that and analysis of it. But I think the thing that we sort of hang our hat on is that, you know, climate change, whether, you know, you believe that's being caused by fossil fuel emissions or not, that the data shows that the climate is warming, and a warming climate is water change in Colorado. So we have seen, for example, peak runoff in the state shift by a month, which has all sorts of implications. Not only do we have a shorter winter season, but the timing of when the snowpack is melting and filling reservoirs has changed by about a month. And so, we are having to adapt. And an important part of that in Colorado is storage and making sure that we have sufficient storage buckets that we can capture that supply when it's coming, so that then we can put it to use. They're all important. I mean, it's equally as important that we have healthy watersheds that then, we're not seeing when that snow does melt, that it's just a complete, runoff like we see in burn scar areas, that it's actually making its way into streams and rivers, and we're able to use that both recreationally for the environment and for ag and municipal growth. So that's not a very direct answer, but it's a complicated question, and it impacts virtually everything that we do. And there's quite a bit of conversation about that in the water plan.
What was the 700,000? What were the units on the 700,000 supply gap? Was that acre feet?
Mm-hmm.
Okay.
Acre feet, yeah.
Okay. And when is that projection? What's the timeline on that?
So that projection in the water plan is 50 years. That's kind of the horizon that we look at.
Okay.
But as I said, the difference in this water plan was looking at scenarios. Mm-hmm. And so, we recognize that is just a projection, and projections can change based on how we grow as a state and the choices we make around conservation and land use. And
okay.
Yeah.
You mentioned helping entities have access to the IRA money.
Mm-hmm.
Is there any remaining funding in that?
Federal funding or our grant programs?
In the IRA program that you can access for your program?
So we provide grant funding through the technical assistance program that we operate. We do currently have funding available for that. We recently refreshed that. The federal funding is available. It's just complicated because it's essentially been frozen. The federal government saw that, I think, largely as being a Democratic Biden administration initiative, and wanted to take a harder, closer look at what the funding awards have been made out of that. So there have been certain projects that have been released that have gotten their funding out of the IRA and the BIL, But a lot of those programs, like EPA, for example, operates a Water Smart Grant program that a lot of our partners have relied on for funding for water conservation projects, and that funding has really been locked up. And there's a lot of uncertainty around what's going to happen with that, and if they're going to, you know, take a look at the awards that were made and then release them, or if there's going to be an effort to redirect that funding. We don't really know at this point. Yeah.
Any other questions?
I have a comment.
Yes.
Yeah, so thank you, Lauren. That was
Yeah,
a great
you bet.
presentation. And thank you for mentioning the water plan. I was just looking at it and we're not very visible there, but I think that might be a product of sort of a legacy of being fairly siloed. And that's something we're working on. So there are a lot of agency actions that I think could really inform the strategic planning that we're doing. We just kicked off. I'm sure Justin has a million ideas about how to integrate some of those agency actions into our work. So thank you for pointing that out
Yeah.
for the further conversation on that.
Yeah, it'd be great for some of our lessees if the loan program were available to them.
Yeah. I mean, the other thing I should note is that we are beginning the process of updating the updated water plan. So this would be the third iteration of that. We're starting the technical work, the technical update, and looking at all of the various projections, and then are going to be starting to work again with the basin roundtables. And so it will be a new opportunity to work with the State Land Board and try and, you know, identify some things that we can do collectively. So that'll be they're every 10 years now. So that'll be out in 2033.
Lauren,
Yeah.
I remember something I wanted to ask, and maybe you could share sort of an overview of what the state of play is right now on the in-stream leasing program. Is it still available to primarily ag users, maybe even muni who can't use it and can lease it back? Could you just give us a high level?
Yeah, so then there's a couple of different components to our in-stream flow program. So that, I think Emma talked a little bit about that in her presentation to you all. So we do both new appropriations, which are water rights that you know, are currently not owned, but there's water available in the system, and we go through the water court process to acquire those as water rights. Then we have an acquisition program where we work with willing sellers of their water rights that want to sell them to us either in part or in whole. And then that still requires, you know, going through a water court process to add a beneficial use for in-stream flow into that. And then we also do some leases where we work with entities around the state that own and operate water projects that have water available for a specific stream reach that would be beneficial for the environment, and we can lease those. I would say those all look different and just depend on what the needs are in those systems. And you know, what we only work with willing participants. We can't force anybody to do it. But if there's a certain project or area that you're thinking about, I'd be happy to set up those conversations.
Sure, Justin is thinking about this all the time, and I just couldn't remember too, if I think there's a limit, a user can only lease it 7 out of 10 years, is it? Or
Yeah, so
is
that's
that still-
recently been expanded. It was 3 out of 10, and now it's 5 out of 10 years. So we do work, you know, like I said, every lease looks different, just depending on the situation. But
the 5 out of 10 is hard legislative, I think.
Yeah, that was a piece of legislation a few years ago.
Thank you.
Yeah.
Really appreciate it.
I just wanted to add my comments to the water, and thank you so much for being here with me.
Yeah,
It's great.
absolutely.
The water plan has come such a far way from where it was started in the skepticism, and the inclusion of partners and the early action associated with that is really remarkable. So I just wanted to, you know, give kudos in the work that's behind that. Working with 50 partners is not an easy thing either. And how that's being translated at the department level and to being so inclusive of all those interests is really amazing.
Yeah, thank you for that feedback. I was involved, I had a different role during the first water plan, but I sat through all of that conversation and hand wringing. And if you had told me, fast forward 10 years and, it's hard to get people sometimes, in the state legislature now to even really care, because it's great. I mean, that's great. I would prefer it that way. But I think that just means that it's not a hot political topic. It's just what we do in Colorado now.
I think Black and Defense are two sets.
I remember that. Yeah,
So-
with Gail Schwartz and Randy Fisher. And,
So
yes.
it's great. And I think it's appreciated. Actually, people value it.
Mhm.
And that is really, and it's kind of foundational, I think, to a lot of good work that's happened.
Yeah.
And will be.
Yeah. Well, thank you for that.
Yeah.
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 And I remember that whole conversation about how the legislature was going to be involved in the water plan and what role they played.
Or should not play.
Or to not.
But not play.
Thank you again so much.
Yeah, thanks
you.
for having me. I appreciate it.
thank
Let's,
you.
we'll be
Great
in
to
touch
see
and
you.
working together in the future. Yeah. Yeah.
So it's fun to have Lauren here. Through my 20 years in the water world, I've just kind of nibbled around the edge of CWCB and have never really directly interacted with them. A lot of the water rights that the land board owns in ditch companies, there's almost not a ditch company that when I go to their annual meeting that they don't have a line item that says CWCB loan because they've updated a head gate or a diversion dam or whatever. So they're always very appreciative of Lauren and her staff. And the in-stream flow thing is interesting. I've engaged CWCB on some water rights that the land board owns, and for those purposes. And so we'll see where it goes. It's been fun. It's been interesting, and Lauren's staff is fantastic. So, how are this morning's presentations? Were they helpful?
Yeah.
Any aha moments?
From the proverbial hydrant, for sure.
Right. New perspectives. Anything coming to mind?
Been great. Lots of great information.
Great. Good. Well, I'm glad to hear that. Something I was aiming to do this morning was to be very interactive and relational, because that's what water is about. And Emma, I think, said it directly, or at least alluded to it, is it's about the people. And so it involves everything that people bring and the challenges that we bring as well. So there's a lot of trust that's involved and collaboration. And that's the theme I want to carry forward through this final presentation. How relationships drive the success of the land board's very own water program. So just a quick note about the photo that you're looking at on the screen. So last month you voted to acquire the Lake Fork Ranch up in Lake County. This is a photo downstream of one of the diversion dams that you purchased on Lake Fork Creek. So it's a beautiful place. We'll need to go visit it. First. Click the mouse first. Okay, we're working. Okay, so this morning, we heard from the state's top water official, Jason Ullman. We explored water law with Emma, and then we talked with the agency that helps shape policy and implement it throughout the state with Lauren. Now let's bring it home, like actually home to the land board. So where does the land board fit in this water system? And in short, the land board is a water user, and we're a fairly large one at that. Our water rights support grazing, wildlife, recreation, agriculture, and even municipal needs all throughout the state. Okay, so on this map, each yellow water droplet, so the yellow is not an indicator of quality. It's simply so you can see it better. Each yellow water droplet represents a water right that the land board owns all over Colorado. So it may be groundwater, it may be ditch shares, both or shares of a mutual ditch company or a private right, maybe a reservoir right, springs. This doesn't include small exempt type of livestock wells. And it's also not 100% comprehensive. I kind of went off the top of my head when I'm going through all of the water rights inventories and water rights cases. This is kind of what's in my head of where all of our water rights are. And so I didn't put it together using my list necessarily, but so with those qualifiers, does this map hit you in any particular way in terms of volume of the droplets or geographic distribution?
Not too much up in the northwest, is there?
Not a lot in the Northwest, which is interesting because there's a lot of water in the Northwest. Yep.
I guess in the Northeast, when we heard about the Republican River and the various constraints on that, what might be impacted with the water that we have there?
Yeah, great question. So the Republican droplets would be in this area that, so those ones. I can get you more detailed numbers if you'd like to know those.
And the ones, are they aligned with? No.
These?
Yeah, that's the Platte.
That's the South Platte. Yep. Yep. Assets along the Poudre River and all along the South Platte there. Yep. And even down into here, but here's more Denver Basin groundwater. When I look at this map, I think about the water rights around the state that the land board owns. I think about each droplet representing a variety of relationships. There are relationships with our lessees, because we rely heavily on our lessees in all lines of business. Relationships with the ditch and reservoir companies where we own shares or we interact with them. Relationships with Jason's staff throughout the state, and also our neighbors, our very interested neighbors, usually downstream neighbors. So as I mentioned, managing water in Colorado is as much about the people as it is about the actual pipelines. And again, as I mentioned, we rely on our lessees heavily every day. And so I want to talk briefly about two important lessees of the land board that are circled up on this map in red circles. The south red circle, of course, many of us will recognize, is our very own Lowry Ranch, just east of Denver and Aurora. And then the other circle is up north in northwest Weld County along the Colorado-Wyoming border, and that's the Terry Ranch. These two water leases together generate more than 70% of the water program's annual revenue, and it's primarily through municipal groundwater leasing. The Lowry's isn't exclusive to groundwater. It's shifting more towards other water assets on Lowry, but historically it's been groundwater. And then on the Terry Ranch up in Weld County, it's exclusively groundwater. So this is what I find kind of fascinating is even though these two leases drive most of the water program's revenue, they represent, as this map shows, only a small fraction of our overall water holdings throughout the state. And most of these yellow droplets throughout the state are tied, as we talked earlier, they're tied directly to parcels. They can be moved around, but they are actively being used on land board properties for things like livestock and wildlife and irrigation, primarily irrigation. So let's keep talking about the land board's water. The leasing does go beyond just the two municipal leases between Lowry and the Terry Ranch. We do lease ditch and reservoir shares. The land board use land board lands for groundwater recharge ponds, especially in the South Platte. And we're, as I mentioned earlier, exploring environmental leasing with the CWCB to support stream health and habitat. Something that I think I've maybe brushed on in the past is Chris Smith and I were talking a couple months ago about it sure seems like there's a lot of interest in land board properties and reservoirs. And so we counted up the planned or proposed reservoirs that we're encountering both in water rights or just in conversations where people have approached the land board. And we counted about 20 to 30 proposed reservoirs throughout the state that would somehow involve land board properties. And so I think there's a role for us to play there, and there's also an opportunity for a new type of lease that we're fleshing out, and I hope to bring to you in the future. And so it's fun and fascinating to see the full range of value of the land board's water assets, from agriculture to cities to ecosystems. Okay, so the business of water. Emma talked about this a little bit, and I'm going to get into it a little more in depth. So this morning we've been intentional not to dive too far into the weeds, because there are a lot of weeds when it comes to water. But this point, I think, really bears repeating that Emma really tried to drive home, is that water is real property, but it's not like land or minerals. We don't own the molecule of water. We own the right to use it. And that right is for a specific purpose. It's for a specific place often. It's for a specific way. And those things can change, and they do change over time. So every line of business within the land board, we have to advance our dual mission, right? We generate income, generate revenue for our trustees, for our beneficiaries, excuse me, and to responsibly manage our assets or stewardship. And so with water, that mission comes with some unique limitations. Several lines of business have the ability to develop an asset almost specifically for profit. This isn't the case with water, because, as Emma mentioned earlier, water is a public resource. We can't develop it just to make money. That, as Emma mentioned, is considered speculation, and it's prohibited under Colorado law. What we can do is develop, and we do this, is we develop and manage water rights for legitimate beneficial uses that generate income along the way. So let's talk a little bit about water markets, the business of water, because understanding the value helps us make better strategic decisions. The price of water depends on a couple of different factors: use type and reliability. So use type, we talked about a little bit earlier. That's the beneficial use. And so when we're talking about water in ag, it's going to have a price that's different than a municipal use, that's different than an industrial type of user. Specifically, since we're often in the business of leasing, and these are numbers that I've encountered. I don't think they're necessarily completely market representative, and I'm working with a consultant to really flesh these numbers out. So take this with a grain of salt. The numbers that I've experienced is in the agriculture world, leasing is about $30 an acre foot. So if we were to lease our water to a irrigation user, that's around the market price that I've seen. Of course, irrigation, agriculture, it's essential and it's foundational to everything we do. But it also is the least expensive, or it doesn't bring in the most revenue necessarily. So then we move on to municipal use. This is, I consider it kind of a sweet spot. Municipal use is a steady demand. It doesn't go away. And what I've encountered and experienced thus far is their leasing is higher, of course, than irrigation or agricultural use. I've seen about $500 an acre foot. And then finally, commercial and industrial use. This is these numbers are wild because it just completely depends on the use itself. So think oil and gas, think mining, that sort of thing. It has a wide range. So I've seen and experienced $1,200 an acre foot all the way up to $3,600 an acre foot. It's wild. So that's the use side, right? So again, irrigation, it's going to be steady, it's foundational, doesn't bring in a lot of money. Industrial, it could be gone today, it could be here today, gone tomorrow, but it does pay a lot. The other part is of a water rights value is the reliability. So we talked a lot this morning about first in time, first in right, shortages, scarcity. So reliability comes from seniority. So if you're the first in line, as Emma mentioned in the lunchroom example, you have more of a guarantee of getting fulfilled in your water right. So seniority and then location. The more senior and upstream a water right is, the more flexible it is and the more value there is. So if it's a senior water right located high in the system, it can be used in a variety of places. It's less vulnerable to scarcity because it's at the water source. So where the snow is melting, it can be captured and distributed from there. And I'm partial to groundwater. I was a groundwater commissioner, so I appreciate it. I understand it a little bit more. And I would argue that groundwater can be as attractive or more attractive in some instances because it doesn't evaporate. It's super reliable. It can be super reliable. When a stream is dried up, you can still pump groundwater. Put an asterisk on that. As we talked about earlier, it depends on the type of groundwater, right? So if it's tributary groundwater, there's going to be more restrictions, whereas if it's non-tributary, there won't be as much. Side note about the photo that you're looking at, this is up on the Terry Ranch, on the land board's property on the Terry Ranch, where our lessee was drilling earlier this spring. Okay, continuing on with the business of water. So we've seen this graph before in some of my other presentations, and I think it's a really good example of what can happen to water's value, dollars value over time when it moves from traditional agriculture irrigation use to other economic sectors. So this graph is showing the water supply and storage ditch company, which is located in northern Colorado. It is located pretty much in the Poudre River Basin. Its water source is both Poudre River Basin and Colorado River Basin. So it is a trans-basin diversion water source canal. And so historically, it has served a lot of northern Colorado for irrigation purposes. And then for whatever reason, in the 2012s, let's say 2015s, more municipalities caught wind of it or realized its value because it is a trans-basin, fully consumable resource. And so you see what happens to the dollar amount. It's kind of, it rose quickly. And it's an example, this ditch is an example of when all the conditions are right. So it's located high within the system. It's it is senior, but it's also trans-basin, so it has the fully consumable element. And I liken this particular ditch system to Boardwalk on the game of Monopoly. So you want to own it, you want to hold it, because you can see one share in 2022 was around $4 million. It softened a little bit. Some more recent transactions have been closer to $3.8 million for one share. So I want to keep that in mind. Keep that rapid rise in mind as we talk about the business of water. And a couple slides ago, I mentioned the different lease prices that I've seen. So if water supply and storage, if you can buy it for $3.8 million, one share has been said to deliver 100 acre feet to the head gate. So if you're an irrigator and you have one share, you have 100 acre feet to a head gate. Playing that out in dollars. So if you have 100 acre feet and you're leasing it for $30 an acre foot, that brings you to $3,000 annually, or 0.08% annual income yield on your purchase. So if we're thinking about our fiduciary responsibility, it's not a great cash flow. Then we go to our next economic sector, the municipal. So it's a little bit different because for this ditch company, you don't get 100 acre feet delivered to your head gate for municipal purposes. That had to be changed. And so you get historical consumptive use acre feet. So that's between 50 and 60 acre feet of historical consumptive use. So let's say 55 acre feet at $500 an acre foot comes out to $27,500 or 0.7% annual yield on your $3.8 million investment. And continuing down in the industrial use, industrial users would be using the same volume or would have the same volume available as a municipal. So 55 acre feet. And let's say, just for math purposes, $1,500 an acre foot, that gives you about 82,500. So we're actually getting to whole numbers now, 2% annual yield on your 3.8 million investment. So I wanted to camp here just for a minute because water is a fantastic asset in retaining and appreciating in value. But it's not great in cash flow. So I guess I just want us to consider that when we're considering purchases, disposals, those sorts of things. Okay. So the land board, water business specifically. So to meet our dual mission of income generation and stewardship, I like to liken the program's work as a trident, more for levity, but it is three prongs, so to speak, of offense, defense, and management. So we'll first talk about offense. So the offense side, this is the side that I enjoy. It's fun. This includes acquiring assets, selling them, leasing water rights to strengthen our portfolio and generate revenue. It also includes managing existing leases. I was texting with one of our leases this morning and doing some negotiation, developing new leases. It's fun to be creative and exploring new opportunities like in-stream flow or groundwater recharge. And as I've continued to mention, that it all depends on relationships. Sorry, the graph you're actually looking at. So the water program has existed prior to me, right? I'm the first water program manager, but there have been water leases prior to me. And so this is the revenue that occurred. And I came on board, or my position was created in 2022. And so you can just kind of see I hope to continue that upward trajectory, basically. No. I plan to.
There, Justin.
Yeah.
When you go to those early years, are those pretty limited numbers of projects?
Yeah, that's almost exclusively Lowry.
Yeah.
Yeah. Yep.
So you've increased the sort of portfolio of sites as well as the.
I can't take exclusive credit, but it has increased during my tenure.
And considering you're the only person in the water, you do the math.
But I will give credit though, the Lowry lease for forever paid very little, because very little has been happening out there. But more recently they have developed it and it started to actually pay. And so that's why I'm hesitant to take credit for it, because it became in existence when I was born. And so I can't take credit for that. So anyways, I'm a beneficiary of it. Okay, defense. So that was the offense side. The defense. This is more about protecting what we already have, and not just water. Because of Colorado's unique water laws, as we talked about this morning, water right holders can sometimes build or maintain infrastructures on land that they don't own. What's the word? How do you say the word?
Which word?
Use-
Where's-
yes.
Preparatory.
That one. I can never say it right. So thank you. It's what we pay our attorneys for. So water right owners can use others' lands to build their infrastructure to bring their water across other lands. That includes state trust lands. And since land board owns so much land across the state, it's happens frequently. And so to safeguard land board assets, and let me back up. So that's not a problem. They just need permission, appropriate permissions to do so. And we're not going to stand in the way of that. We're just happy to lease them the land. So to safeguard land board assets, staff and our legal team review roughly around 800 water court filings every year to make sure that no new or modified water rights infringe on our assets, so land, water, minerals. Sometimes, most of the time I endeavor to do this, but sometimes this defensive work turns into partnerships. It's more relationships. I try to turn our defense into offense. Okay, and the management. This is where I bring items for you to fund, to make a decision and fix our things that are broken. This is where we work hand in hand with the Division of Water Resources, Jason's staff, and other agencies to maintain the infrastructure that we own. And it ensures that our water right is being put to beneficial use. So it often means repairing head gates, updating measuring structures, maintaining reservoirs, dams. I'm sure many of you recall the Brett Gray Dam Rehabilitation Project presentation and presentation or project, too many P's. What you're looking at, the photos, this is one of the dams at the Brett Gray Ranch, the before and the after the tree removal and the shoring up of the dams. And this also happened out on the Chico Ranch as we visited this summer. Another recent upgrade or project was on the Sherman Creek Ranch in Jackson County to update some measuring structures and to clean out some of the ditches of water rights that the land board owns up there. So this is the day-to-day stewardship that keeps our water productive, legal, and valuable. So that, yeah, this photo is from I think it's called the Chase Ditch on Sherman Creek. So, okay. Looking into the crystal ball, so to speak, for the land board and the water program. We've talked a little bit about dry up, and we've talked extensively about the Republican River Basin and dry up in the Republican River Basin. What I want to point out with dry up is what we've learned with the sale of our groundwater in the San Luis Valley is to dry a landboard property up. It's going to take years of work to revegetate a property and make it productive again in some capacity. And so we're endeavoring to identify those resources or those assets that are at risk of being dried up in the future and start working towards that now, because it may take a 5-year planning process in order for us to be able to do that. The other, yeah.
And part of that, the lesson learned from the San Luis Valley is when to keep the pivots in place and
Yeah.
when to remove them. So I think you're right, the years of planning process.
Yeah. The other future thing that I see in the crystal ball is, as I mentioned earlier, is reservoirs. And future planned reservoirs interacting with state trust lands and what opportunity could be there for the land board to capitalize on. And finally, when we look at how water's been used over time, zoom out to beyond the land board, even beyond state of Colorado. When we look at how water's been used over time, it reflects society's evolving priorities. Because water is fundamental, foundational to all of society and all of our economic sectors and everything we do. Settling the West was the origin of our state. And it's also the beginning of our rich water history. In recent decades, there's been a growing emphasis on using water to benefit the environment, restoring streams, sustaining ecosystems, and preserving open spaces. To me, this suggests that maybe much of the West has been tamed. And now the value of less developed, less altered landscapes is gaining recognition and momentum. And within a water administration system based on scarcity and who put water to beneficial use first, this new focus is sort of late to the water beneficial use scheme, and meaning it's a junior water user in a system where most of the water has already been allocated. And so these sorts of uses have to compete with other well-resourced junior users, such as younger and growing municipalities, and other new junior industrial users that, again, that are well-resourced. I think there's an opportunity for the land board there, though, and I'm excited to be able to explore it. So in short, this picture is also one of the Brett Gray reservoirs I took it this spring, post tree rehab on the dams. So, okay. In short, the land board's water program, as hopefully you've caught, is built on relationships for the sake of generating revenue and stewarding our assets. We work with our neighbors, our lessees, partners across the state to ensure that the water entrusted to the land board remains productive, legally sound, and to the benefit of Colorado's schools and communities today and for generations to come. And as we move forward, I will continue to bring to you opportunities where I think we can enhance income generation, strengthen our water and land assets, and deepen our connections with Colorado's broader water community, sort of as we've done today. So this photo is one of the reservoirs we partially own with our Williams Park acquisition a couple of years ago. So they're beautiful places. We didn't take you up there with the.
I was just gonna say.
No.
it's the dune buggy.
Yeah, right. So, well, with that, I'm in the way of lunch, but I'm happy to take questions.
I have a question, sort of, a couple things. One's a very specific one. When we look at the revenue of the water program, is that net of all of our costs? Is that gross revenue, or is that net of, the defensive costs and the management costs?
Yeah, it's gross.
It's gross.
Yeah.
Because those are very lumpy,
Sure.
the costs that we have, right? So I was just
Yeah.
curious.
So a couple of the costs. So going off the top of my head here, we used to one of the costs is ditch and reservoir share annual assessments. We used to just send those assessments on to our lessees, and the lessees would pay them. We still do that, but in a roundabout way. So we pay the assessments directly, and then we rebill our lessees. And the reason I wanted to do that is because there are chances that if our lessees didn't pay, that our assets could be at risk for being taken back by a ditch company. And so I didn't think that was appropriate for lessees to have that responsibility. So it's a cost, but not really, because we're reimbursed. The other costs, I suppose, would be my time, Emma's time, not just Emma, Chris and Aaron and
Like
They're-
Lowry. I mean,
Right.
my gosh.
Yeah.
I can't even calculate. how much
right.
it costs.
Yeah, all of my colleagues and their time. And then whatever we end up spending on our assets, like rehabbing Brett Gray dams and fixing measuring structures on Sherman Creek and all of that.
So my larger question, which you may not be able to ask, is in some ways, we looked at the current returns. Not too attractive. And like land, but different, we would look to future appreciation. but the nature of this asset and to what you said, how important it is to people, wildlife, communities, industries. I'm curious how you think about our ability over, the time to monetize these assets and capture that capital appreciation, given the implications.
Right.
of Water.
Right, without selling, right?
No, selling. No,
So-
I'm
okay.
saying for us to, exit, how would, perhaps there are some alternatives beyond current leasing that would allow us to capture the capital
Mhm.
gains without selling it. But I was thinking of the problems with selling.
Yeah, the problems with selling, you don't know when the market peaks, right? So there's a timing.
And who's going to fight it and what are the implications? And it's some of the conversations we have around our assets that are leased for public use. Do they become stranded assets? Do they? So maybe just planting that as a consideration within the water program, because I was thinking about that as I was trying to wrap my head around capturing the ultimate value of some of these. Like, had we bought those water shares in 2015 on the slide, that would have been one heck of a return if we were to go on and sell them.
Right, exactly, until it's realized.
Right. Mystery.
I was just, thank you for your presentation too. I was gonna say, even the relationships also with the soil, with the wildlife, with all that enhances that property makes me really question how we value that water as a revenue source, because it seems to me it enhances the properties we hold. And, so I sort of struggle with how we monetize that piece of it, because the soil absent the water, the ground absent the land, the animals absent that, it degrades dramatically. So,
And so you're sort of speaking to the qualitative, like, how do we value something qualitatively
right.
as opposed to just quantitative?
Can I suggest, on this point, that the value of our water portfolio, it comes through in other lines of business too. So ecosystem services and recreation would be the most apparent. So it may be that the actual yield is much greater than what you put on the slide, Justin, because we are creating opportunities for, I think, wetlands mitigation banking, for example, maybe some species conservation banks, recreation attributes of properties probably going to be greater if there's water.
Right.
CPW told me that only new parks need to have big bodies of water on them. That's what people like. So I do think that there are ways we can monetize as we go. But I was thinking along the same lines, Deb, on, the sort of end game when we dispose of the water right itself.
Mr. Pribble?
Thank you. Well, so to the point raised by the chair, before we sell or monetize a water asset, first we need to own. So the question is, how do you search for, and what do you have in the queue or the lineup for acquisition of water rights, and talk a little bit about how the intersection between you and Matt LaFontaine in acquiring property, building a list of prospects.
Sure, yeah, I can talk about that a little bit. So one of the easier things that are sources of acquisition is our lessees themselves. What prompted this whole conversation was in Alamosa. I brought some new language to our leases, and just getting input on that, and the commissioners wanted a broader perspective of the water world in Colorado, and so that new language in our leases gives us the first right of refusal when a lessee brings their own private water onto state land board. So that's I don't know that it's low-hanging fruit, but it's things that are there. The other thing that comes to mind in sourcing acquisitions is as I've been hammering on is relationships. We do have one in the pipeline that it's not a, I don't know, what do you want to say about it?
Yeah, so I would add, first, before addressing that oftentimes water rights are sold along with listed properties. So the majority of our water right acquisitions are in conjunction with other ranch or large property acquisitions in general. But we also are becoming increasingly known as a potential buyer of water rights. So the one that Justin just referenced, and I think it would be premature to talk about details of it at this time, was made available through a relationship that Justin has. We reach out to potential market participants. We have our own, we call them buyer calls, but essentially a pitch as to why the state land board may be the best follow-on owner for certain water rights. And we just try to get the message out that we oftentimes have access to acquisition funds that utilize to purchase water rights. And we have the land and relationships in place to put those water rights to beneficial use.
It's something I have to balance too, of when there's a potential acquisition of, and Emma talked about this, of are we going to be viewed as speculators? Because there's nothing stopping us from acquiring some of these water assets, but can we put them to beneficial use, or are we just buying them to buy them and lease them to others? So it's, yeah. Does that answer your question, Commissioner Pribble? I think you're muted. Fair enough.
Sure. Yeah, it helps. It helps. I want to continue to learn more about it. Thank you.
Great. Yeah.
Thank you very much, Justin.
Yeah.
This was a great morning. Lots of dimensions, and I love that
Yeah.
everyone kept it at the high level. Because a lot of times we've had some sessions where we're talking about the specifics of like the Republican basin and all this, and to me, it was very, very nice to be at a high level, and Emma especially, thank you for your presentation.
Yeah, that was foundational.
Very
Yeah.
Great.
Thank you all. Now, I think, do we want to move to the next agenda item on the work group?
We could, or we could take a break and get lunch.
Well, that's what I was wondering, is want to get our lunch and then maybe have this conversation while we're eating.
Sounds
How does that fit with you all?
Yeah.
Okay, so let's take a 5-minute break to rustle up some.
What sort of time frame do you see forward?
Director, I think it's up to us too, how much we want to delve into it.
Yeah,
What
so
do you think?
Nick and I think like maybe 15-20 minutes, but you know, to the extent you want more conversation, it's really an important issue, the work group. So we're really at your disposal. Can be quick.
What's that? I missed that. Sorry.
So why don't we, we're thinking about a time frame in terms of the discussion around the conservation working group,
Right.
which is really at our discretion.
Yeah.
Perhaps it would be helpful if we get our lunches, aim for a noon start, and then we try to wrap up as imagined at 12:30 or so.
That's good.
Okay.
Great. Breaking till noon?
Yes.
Commissioners, just doing this for the record, I've opened the mic and the camera. Sure.
Right.
All right, Director.
For the record, Director Rosarino, with me is Director Passy. We are going to tag team this presentation because we are tag teaming this effort. This really important effort. We're really pleased to update board on HB 25-1332, the State Trust Lands Conservation and Recreation Work Group, and this will be first in a series of updates that we will provide the board throughout this process, which, as you may recall, will culminate in a set of recommendations being made by the work group to the board that we need to take up as an agency by February of 2027. So our plan is to give you updates throughout this process so that you're fully informed, because it really is very important for a number of our lots of businesses I'll touch on. So as we do as staff, when we present to the board, just wanted to give you a reminder of what lines of business are most involved in this effort. Ecosystem services and recreation would be first and foremost, given the scope of the work group's responsibilities, but also agriculture and to a lesser extent, renewable energy. So then I just wanted to give you a reminder of the law itself. This was passed by the General Assembly in the spring and signed into law by Governor Polis. The prime sponsors were Representative Karen McCormick and Senators Roberts and Wallace. And there you see the specific scope of the work group, which is to provide recommendations regarding conservation, climate resilience, biodiversity, sustainable, equitable, and low conflict recreation.
Just wanted to say a few words about the timeline involved in the bill. Certainly, as things were coming together, we were pushing to give this as long a legs as possible. Well, you see in front of you kind of where we landed. In the fall, we had a deadline to see the working group built and get some things set up. That's behind us now. February 1st, the State Land Board, essentially staff, have some deliverables that are due, that are owed to the work group itself. There's some information that they would like to have in hand to help guide their process and guide their work in this. Mid-March, we've got the interim report due, and that one, as well as the final report, have visibility at the governor's office with our legislative committees of record, being natural resources, primarily both houses. And as well as some reporting up to DNR leadership. Director Gibbs is going to have an opportunity to look at what's happening midstream, as well, he's involved all the time, but he and his team, his office will have the ability to put fingerprints on the interim report as well as the final. And then this board as well. We want to make sure that, to the degree that you have needs to be involved in the process, that you can be, acknowledging that we've got some challenges around timing. There are places where our board meetings don't perfectly align with due dates and things. So let's be in regular communication as to what information you need, what updates you need, what participation you need to make sure that everyone feels good about this. I wanted to just say briefly that this bill came with a specific appropriation. So we are footing the bill for the costs of this working group. We got an appropriation, I want to say something around $450,000, which over the course of essentially 2 years of the life of the working group is supposed to cover the consultant that is helping us put everything together. And I say us, meaning everybody involved, as well as we're going to make sure that folks can participate in person as much as possible. So with travel costs and things, and we're doing our best to be exceptionally gracious hosts of meetings and making sure everybody feels good, eating well and being well taken care of.
Please go ahead, Commissioner.
Oh, what kind of deliverables were they interested in from us?
I'm glad you asked. I'll say a few words about specific things related to that February 1st deadline in a minute.
May I ask a question too about that? I'd understand the legislation that the interim report and the final report will be made to the legislature. And does that mean that they vote on anything, or this is just an update and then we end up responding by February as to maybe, hopefully, we're implementing it all and everything's great, or what pieces we think are not possible, is that right?
So in the fall of 2026, it's the time for the legislature to see what the work group has been up to. And then there is a deadline of by February 15th of 27 that this body should have taken into consideration the recommendations made by the work group. There aren't prescriptions on what consideration means. It doesn't prescribe particular actions necessarily. I mean, there are some actions staff will have to take as an output of this work. But in terms of this board, there needs to be a conversation that acknowledges the work group's recommendations, and perhaps as we're practiced in doing, this board makes requests to staff on how to take action or to consider action and report back to the board.
Are you going to get into who's participating?
Yes. Yes, and so just a little more on those reports is the interim report and the final report are just reporting innocence to the General Assembly and the Governor's office. The real work, I think, for us is going to be, well, the real big focus time for policy considerations will be between September 1st, when that final report is issued, and February 15th of 2027, when we have to take those up. And so, yes, like Nick said, we'll definitely be coming to you with proposals for potential policy revisions, new policies that are informed by that final report due September 1st, 2026 from the work group. And so we are engaged in several different ways in implementing this law. I serve as a technical advisory member. As you'll see in a second, there are a number of technical advisory members. As Nick will provide in detail, that report that's due by February 1st, 2026 from the State Land Board to the work group is really going to be in depth. And it has a pretty compressed time frame. So Nick is going above and beyond to make sure that report meets the needs of the law and the work group. And then that February 15th, 2027 deadline that I mentioned to you is really where you all will be considering potential policy changes. And then I also wanted to mention that multiple staff serve on the planning committee, and both assistant directors, myself and Nick, and we will be tapping different subject matter experts from our staff, particularly on ecosystem services and recreation as we go forward. So here's to answer the question about who's on it. There's a range of different backgrounds represented in the law, and the appointments were made by the governor, legislature, and tribal representatives were sent from the Southern Ute and Ute Mountain Ute. So you can see here is the education, agriculture, conservation, and recreation sectors being very well represented. And then next are the appointments for.
Does anybody need a minute to look at those? We're good.
And we'll provide these slides to you, of course.
Taisha Adams. Also.
Taisha Adams is for local government. Yep.
Okay.
She's on there. We have oil and gas,
Okay.
minerals, and renewables. We have affordable housing sector represented, and then Taisha and Commissioner Hulk are serving for local government, and then, as I mentioned, both of the tribes. And then that's right, and that's why it's so essential that I just want to take a moment that we have the facilitators that DNR has hired. DNR's executive director's office is really on point on this, particularly Aaron Ray. And then bottom lining for the State Land Board is Nick. It's really a team effort because it's one of the largest working groups I've seen. And so at the top there, you have different members of the group from different areas of expertise, finance, legal, as well as water resources. And then, as I mentioned, the technical advisory members, and those are largely from state agencies, so State Land Board, DNR, CPW, CDA, and others.
And I'll throw in there that it's a really nice mix of partners that we really enjoy working with and partners who challenge us in interesting ways. So looking forward to getting all sorts of constructive input over the course of the coming months.
I'm guessing most of those folks don't have familiarity with the land board.
That's, I think that's a fair representation. And so I'll talk about how we are trying to meet that gap in a second. As I described the October 30th meeting, which was the inaugural work group meeting, which I must say was off to a very positive start. And helping to set that really proactive tone was Executive Director Dan Gibbs and Prime Sponsor Representative Karen McCormick. So that was just really terrific. And then the work group members introduced themselves and described what issues were top of mind for them, why they wanted to be at the table. Then DNR, we did an in-depth presentation on the scope of the law. There are a lot of things mentioned in the law, but the actual scope of the study is narrower. And it's those 4 things that I mentioned before: the conservation, biodiversity, climate resilience, and low conflict recreation. And so I think DNR's presentation was a really good focusing exercise, that this is really your charge. And so that was helpful in setting the stage. I'll talk about my presentation in a moment. But overall, the takeaway from the planning committee, of which we are a part, is it was a really wonderful collaborative spirit that we saw percolating up, and then respect for what we do, respect for current uses and lessees, and for our charge, for our fiduciary duties. So really just an excellent meeting. Let's go to the next slide. We went into it with a plan. We recognize that probably some of the folks at the table might not have intimate familiarity with how our agency runs and the work we do. And so we did our typical State Land Board 101. So walk them through our history and our mission and the revenue generation that we see and the benefits we provide to BEST and school finance. But then we went into more depth about the conservation, recreation, and agriculture sectors in particular. And the idea was to describe sort of how far we've come and provide some ideas or questions where we thought the work group's ideas would be really helpful for continuing to advance our progress in these areas. And I'll just give a couple of examples. So for conservation, there's a lot of scrutiny in HB 1332 on stewardship trust. They're very open to new and creative ideas about how we can enhance the standards of protections for stewardship trust parcels. We're interested in knowing whether there are new or amplified approaches for monetizing ecosystem services. That kind of intersects with the conversation we were just having on water, including through the use of conservation leases. And then on recreation, is there support among the work group for our innovative recreation ideas that I know Elliot and Abe have been working hard on, such as campgrounds and agritourism and ecotourism? Maybe there's more ideas among the group for creative recreation leases, but also whether there's support for these new uses. And then in agriculture, how can we encourage more of our ag lessees to transition to regenerative agriculture and build in support for native animal and plant communities in their grazing lands? We had a long list of ideas. I think that the group was very receptive. We can fill you in more as we go. Thanks.
So for those of you that have a copy of the statutes on your nightstand, the bill modifies CRS 36-1-152.5 to lay out the work. One of you asked a question about, what are some of the deliverables of February 1. I just wanted to take a quick minute to remind the group that it's been essentially 30 years since the passage of Amendment 16 that created the Stewardship Trust. And the things, most of what's asked of the state of us as staff and as board for February 1st are Stewardship Trust questions. But, a reminder to this group, of course, and we will remind the working group that the Stewardship Trust isn't truly a trust in the same way that our school trust or the other trusts are our trusts. I'm gonna try to say trusts a lot. It's that designation of special care for a subset of or a fraction of our total holdings. And those things are part of a trust in first, largely the school trust. And so those properties still need to meet our mission and our directive from the Constitution of stewardship and revenue. I'm sort of thinking of this as an audit of the life of the Stewardship Trust. I think the work group is asking staff to have us take a look at everything that's currently happening on the Stewardship Trust in terms of leasing and other stewardship activities. Have a look at the things that ultimately didn't happen on the Stewardship Trust. Are there reasons why staff may have rejected or declined to enroll pieces of land into the Stewardship Trust or leases on the Stewardship Trust? Taking a close look, as an operations guy by background, I like audits. It's kind of crazy, but it gives you a chance for an outsider to give you an opinion about the way you do things and maybe find improvements. That's great. So the key word in this piece of statute is shall. Anytime you see a shall, you have to do something. The first piece of those 4 items is, again, taking a deep dive into the leases that are happening currently on Stewardship Trust lands, taking account of the natural values that are present on those lands, and then how things are being managed to accomplish those long-term benefits for the state. And these are my pieces of paraphrase. You might get slightly different interpretations on your own. Happy to argue with you about that if you'd like. The second piece is look at any of those occasions where leases proposed for Stewardship Trust lands were deemed incompatible, primarily with natural values. Natural values comes up a lot as a phrase in the bill. And it's part of the construction of the Stewardship Trust, natural values.
Excuse me, Nick, how many of those are there?
That's a good question. I don't have a gut sense of how many times we've declined to do something on a Stewardship Trust property. And we've got some good tracking from the last couple of years, and it'll be interesting to see how far back we can look. But I think the resounding message is we find ways to do all sorts of things on Stewardship Trust properties because that's our directive. Those are working lands and they're meant to be actively leased. So it'll be interesting to see what comes up from there.
And I would add that it may be that there were more informal points at which ideas for leases were rebuffed by our staff before the application was ever received. There definitely is that analysis and filtering that goes on in those conversations that our staff has with prospective applicants.
We also
may I ask?
Oh, go ahead.
No, I'm sorry, Mark. Go ahead, Mark.
No, that was Elliot speaking. You go first.
Okay. So the reading this language, it implies that outside parties or some other entity other than the board nominates properties for the Stewardship Trust.
Yes.
How many occasions, or it says all occasions in which a lease is proposed for Stewardship Trust and was or denied. So the question is, what is the nomination process? Are there external entities that can nominate?
Yes, and I want to make a distinction between nominating properties into the stewardship trust and considering a lease proposed for the stewardship trust. There's nominating is really a factor of the composition of what is in the stewardship trust. And then leasing is just a matter of business. It's something we do every day. And whenever a prospective lessee partner is interested in doing a lease with us, there might not be a reason for us to steer them away from the stewardship trust, or we might steer them into the stewardship trust properties. But in terms of nominating, there were actions taken by board and staff decades ago that pulled the biggest chunks of stewardship trust acreage into the stewardship trust in big pieces. And that's been 20 years or more. I don't think the stewardship trust came together immediately upon 1996, but there were some definitely big actions where lots of outside parties were encouraged to nominate properties for inclusion. But that is separate entirely from the leasing activity, or at least was at the time. Did I answer your question, Commissioner?
Well, yeah, I mean, I think so. I mean, the wording of this section implies that that somebody was unhappy about something, maybe dating way back to 1996. I don't want to read too much into it, but seldom, in legislative language can notably, at least in my 50-odd years of doing legislative work, can be notably incomprehensible.
In this case, my interpretation right off the top would be this would be staff's interaction with prospective lessees. Someone's interested in leasing property that happens to be in the stewardship trust. It's a staff, perhaps based on policy or whatever, but it's largely a staff decision to allow that lease to move forward.
So it may be that if I hear you correctly, Nick, it may be referring to a lease denied, a lease of a property in the stewardship trust denied.
Yeah,
is that possible?
That's the bias that I'm putting on that language. Yeah.
Yeah. So somebody's got an axe to grind here is bottom line.
Well, it seems like they're trying to, this is going after, is the stewardship trust just a label? Or are we walking the talk and living the mission on that?
Exactly.
So could you explain again whose brainchild this was? Was it
Confused by that.
was it these legislators, the two senators and the congressperson, or was it I'm just curious where it came from, because
the why behind this has been elusive. And it's such a huge group of people doing a giant intervention on our little nice agency.
And it took a lot.
There are more people, honest to God, in this task force than there are staff in this agency. So it's like, I'm really struggling not to be defensive. And I've talked to my friend Dylan Roberts, who represents me. I'm like, what the heck?
So I think the way we're looking
it's
at
nice
this-
we're being positive, but honest.
So I think here's why it makes a lot of sense.
Oh,
for us.
okay, I'm taking it. I will not comment.
No, it's, if we look at what the focus is, conservation, biodiversity, low conflict recreation, climate resilience, that sounds a lot like our innovations. So I think that I can't speak to the origin story, but I think that we have the chance to really use this work group opportunity to advance ideas that we have percolating or we've already acted on. Think about recreation. Think about how Elliot and Abe are trying to diversify recreation in order to grow that line of business, and in the process, invite new users who may not fit into the recreation leases that we've tended to do. So I think I would rather focus on, this is the law. We're gonna implement it really well. And there are ways we can engage that converge and elevate our current. And probably some new brilliant ideas for how we can do even better. I do think that Commissioner Frobus is dead on, that these questions about the stewardship trust are really challenging us to show that the stewardship trust parcels are managed at a higher caliber than the rest of our portfolio. I think what we can also do, which we discussed at this first meeting, is demonstrate that for us, stewardship does not stop at the stewardship trust. It pervades all of our lines of business. And that's on purpose because it's one of our principal pillars through the Constitution. And so I'm not going to the legislation itself, and how it originated, but I do think that this is actually a marvelous opportunity for us to articulate what we're doing well and to be open to ideas for how we can be doing even better.
And I would add just again, as a contributing factor to the origin story, whatever it is that there is the Colorado outdoor recreational strategy. It's been a big thrust within the administration and in the state. It's been a high priority to increase the recreational opportunities. And so I feel like that's also a driver. I see in that the opportunity for us to finally have a much more visible, broadly understood notion of why our lands aren't public lands. So I think that is actually one good thing that can come out of this exercise in the pursuit of public recreation.
Are you guys concerned with trying to manage a group this size in terms of staff resources and how long it's going to take to organize all this stuff and what it's going to take away from everything else you're doing?
Yeah, it's certainly going to be a challenge, and the legislation did appropriate about a person and a half to us that we could hire, which is challenging in a hiring freeze scenario. But over the course of as fast as we can possibly manage it, we'll have additional staff to add to this effort, which is good.
So in essence, it's going to sort of be a giant advisory committee to the commission. Where the commission still makes the decision and these guys bring in new ideas and that sort of thing. Is that the idea? Or
So the way I'm thinking about it is, especially that final report in September, we take that as a staff and we create a proposal for you to consider and whether we need revised policies, new policies that address those recommendations. And that is also filtered through our fiduciary responsibilities. So there are sidebars on this process, but then we will provide that proposal to you as a commissioner, as a commission, and you will have the ability to say yes or no to what we propose coming out of this body. So I don't see the body itself as a direct advisor to you. I see them as creating a product that we can then use to shape staff recommendations.
So I guess the key is that you guys use them; they don't use you. As in, that's not very well put, but I know there's some smart people in that group. So if they can be used as a great resource and it doesn't take away too much of your time, money, energy, maybe it works.
I think it has to work because
it's law.
Well, that one, I'm gonna have a follow-on question
Yeah.
to exactly that. Is anything being proposed that could be put forward as potential legislation as a outcome from this group?
I say it as a possibility.
The door's open.
Yeah, so
Well-
maybe. I'll back up and not be quite so fussy. I mean, 100 legislators voted for this. 98.9% of them have no idea what the state land board is. So if there is an opportunity to better educate them, and give them a chance to better understand what we do. I think that could be a very positive outcome. I think in part they voted for something thinking it needed fixing, which was always my irritation with this whole piece of legislation, and implies there's something that needs to be fixed.
I'm very Pollyanna, so I look at it as, how can we help you do even better?
Right.
You
And
know,
I'm going to take away from all of this that will be a positive outcome from this. Because I think you have a legislature that doesn't understand what we do. We have a working group that largely is people who don't understand what we do. And if all of this moving forward is, hey, we do a lot of we're really forward thinking and very proactive. And if you went to our national conference with all these other state land boards, you can see how much further we are ahead of that game in terms of the stuff that we do.
absolutely.
So if there's a chance to share all of that, it'll be a very positive thing. I've been around the Gold Dome way too long to not be skeptical. And that's all.
Well, Emily's already doing work to really use this to increase the visibility on the good work that we are doing. And I do think that there are opportunities throughout the process to highlight that, one outcome of the national conference was the reflection that we're leading in ecosystem services, in creative recreation, in affordable housing, in renewables. And so that's the message we can take to this work group. And given how big it is and how, broad the potential impact, given all of these different sectors represented, this could be a game changer in terms of elevating our visibility so that when things do come up at the state legislature, we are more engaged. We are being engaged and we are engaging.
Well,
And there are interests and agendas of some folks around this, our work and what they would like to see us do that don't fit with our mission, candidly. And we need to be on guard around that.
Let me just say a couple other points about that February 1st deadline. And to the point of, sort of celebrating the good work that we already do, the group is going to be presented with an accounting of the lease stipulations that we have in place that help our leases be very strong. We talk about that a lot from this table. Staff has done a lot of good things concerning making sure that our lessees perform to a high standard in terms of stewardship, especially. So we'll get to show those things off. And then to the point of other states, the last piece that's due before February 1st is a check-in with all other state land boards to find out what they're doing in terms of recreation on trust lands and how that interacts with other types of leasing. Jim, Commissioner Preble, did you still have a comment or was that an old man? You might be muted if you're.
Jim, do you have your hand up on purpose? Did you want to make a comment or question?
Sorry about that. That stayed up. Usually it goes down by itself. Sorry. No, carry on.
So,
Take this off.
potentially, we're hoping to leverage some of the resources that come with the consultant to help us do some of this research. But we also generally know a lot of this stuff already too, so.
But still, it takes time to put it together.
It does. We have nothing but time. Oh, this is me too. So kind of taking a little bit of a pivot. I want to speak about beneficiaries and trusts because to your point, Commissioner Scanlon, this is an education opportunity for lots of folks in the greater audience related to the bill. And so we want to be clear about the way the trusts work. As you know, these are the trusts and the beneficiaries identified for those trusts that we currently consider under our management. depending on whether you measure by land footprint or value or revenue generation capacity, the school trust is essentially 99% of everything we do, by any measure. And the trusts generally trace their origins back to the beginning of Colorado statehood. There are some pieces that came along a little later, but they represent land grants that were made to the state by the federal government to accomplish a variety of things that were considered essential to the function of a successful state. What's interesting is that this piece of legislature calls out the Internal Improvements Trust and the Saline Trust. The Saline Trust is always one that I think it's interesting to learn a little bit more about because it was related to salt springs. When salt and springs were incredibly essential to people living in hard conditions and other industry, these were also set aside. But what's important about these is it's the legislature that determines the beneficiaries of some trusts, including these two. So the bill, did that change? The bill calls out these two trusts for special attention to be the focus of recommendations by the working group for alternate uses or management. But what's interesting is it's to maximize public benefit. I'm personally struggling a little bit with that language. I think we need to be very strong in our efforts to educate the working group about beneficiary responsibilities and fiscal duty of this board. But I think we can also play ball pretty well to acknowledge that there is public benefit to some activity. And then the legislation goes on to say maximizing public benefit through and supporting the advancement of CPW's mission, and particularly when in proximity or part of state parks or wildlife areas. And there's special mention that state wildlife and area and state park expansion should be considered as opportunities for state trust lands, and as should title transfer to CPW. I think somebody around this table already said there were some very specific agendas in this bill. This one stands out to me as being there's an outcome that some interested party is trying to get to, and I think this stands out as the most obvious one. I wanted to acknowledge that the Saline Trust comprises roughly 10,000 acres. Internal Improvements Trust is about 48,000 acres. Leases on the Internal Improvements Trust lands generate about $500,000 in revenue a year, and Saline Trusts generate about 50,000 in revenue per year. And with state parks as the beneficiary of those trusts, that revenue, net of a small expense charge that we apply, is sent to CPW. So it's this interesting ecosystem of the beneficiaries have great interest in what's happening on those trust lands and would be interested in doing something different. And ultimately, as a revenue generator, it all goes to them anyway. So this is going to be an interesting conversation.
And wouldn't it be reasonable for DNR/CPW to discuss? I mean, they're the beneficiary, so the working group might want to understand that they actually theoretically could help move towards a different reality, but they're getting money right now that helps their mission.
Yeah, this is one of those places. Hold on, Commissioner. This is one of those places where we want to bring CPW to the table to speak about this. And we also want to acknowledge that we're not starting from scratch and thinking about what to do with these particular trusts. We've had lots of conversations over the years with CPW as a partner to say, what are we doing here? What do we want to do here? What works well for us? And so to have it codified in the law was kind of, I mean, I was sitting in the director's seat when this came decided. I mean, this piece kind of frustrated me because it disregarded, it felt like it was a disregard of a lot of work that staff had already put in. And then, somebody's saying, well, it's law now, so now you're going to have to do something about it. I'm with good coaching, I'm getting past that. I'm looking to the future.
So Nick,
Commissioner Prittle, go ahead.
Yeah. So Nick, so it's listening to you, the motivation or this language, which could be inadvertent, it could be out of ignorance, or worse yet, it could be deliberate. With respect to the two you've got highlighted on this slide, and this is out of my ignorance, does either of that have anything to do with the lease of state forest, state park land, or totally separate?
I think in the way you're asking the question, it's totally separate.
Okay.
We
So
have. Mhm, go ahead.
what's in the internal improvements trust for state parks? What is that actual land?
The Loveland building is one of the biggest assets.
Yeah, Chris, go ahead if you want to say that again.
Sure, Commissioner Pribble, this is Christopher Smith. We own a commercial building or two buildings in Loveland that are mostly flex industrial type buildings. Siemens is a big tenant, and those produce most of the income and are probably most of the value of that trust.
And why was it designated solely for state parks? What's the history there?
Well, we acquired those buildings probably 15 years ago through a non-simultaneous exchange. So we didn't
Okay.
always own those buildings.
But
why?
I think the question you're asking is why is State Parks the beneficiary of internal improvements trust
Correct.
lands?
Correct.
And that is a legislative decision that goes back into the 50s is our understanding. And there are folks that know that answer really well. I'll be happy to relay it. I don't have it at my fingertips.
Okay. Well, it's
Prior-
got to be so small in comparison to our overall asset base that I don't want to waste any time on it.
Well, now I'm not sure whether to provide any answer. But prior to 1959, the revenues that were generated from the Internal Improvements Trust and the Saline Trust were dedicated to project-specific internal improvements, things like roads, specific road projects, specific bridge projects, and prison projects, as I recall. And then in 1959, there was legislation that designated parks as the beneficiary, and then as parks has merged, unmerged, and merged, it's been adjusted to accommodate that, but that the revenue sources were to support the growing park system, which I think parks basically started in 1959.
Exactly. That's that. Given my age, I can say that my memory tells me that the state park system was started in 59 or 60. You got it.
Yeah, so this designation, I believe, was contemporaneous with that creation to provide a revenue source for the new park system.
But one of the interesting complications is that wildlife is not the beneficiary. Parks is the beneficiary, and parks and wildlife are combined now, but those are getting conflated in some of the language that we've seen.
So these are distinctions that will make sure this group understands.
Yeah, it's going to be an education process like all of this, but this particular one that, to your point, has been out there and we've been discussing it for a long time, and there hasn't been a simple solution. And we'll get a chance to talk about it again.
And if I may take just another moment, because so those Loveland buildings, as I recall the context, were largely purchased at Parks' request because they wanted properties that generated revenue. Other properties within those trusts are actually incorporated into some state parks. So there's a mix of land within those trusts that are actually being used by the beneficiary for parks purposes, and also sort of unrelated properties that are generating income for that beneficiary. And also the land board has historically been sensitive, even though it's 70 years, I've done my math right, but I went to law school because there was no math requirement. Since there's been any change in the beneficiary, but traditionally the commissioners and staff have been sensitive to the fact that the legislature could change the designated beneficiary of these lands to another purpose. So.
I don't have a nice way of saying, are there any other questions? I want a pretty picture.
Thank you for.
Yeah,
Like,
thank you
good
for what you're
start.
doing. Work.
Brave start.
Yeah, brave start, yeah.
Coming up on, there's the next meeting is scheduled for December 4th. They generally were targeting half-day meetings. I think they'll be as long as they need to be, but a lot of this material concerning stewardship trust is going to be the focus of that meeting on the 4th. We want to get this group aligned to, connected to the good work that we already do, and get some of those harder questions out of the way early. And so, stay tuned for the staff report after that tells you how good we did at presenting that stuff.
I do have a question related to that. Maybe it's a legal question for Ed, and that is, in as much as Amendment 16 was an amendment to the Constitution, establishing the stewardship trust with the 300,000 acre limit, would a recommendation by this group to expand the stewardship trust to double, triple, whatever size, would that need to be a constitutional amendment, or could the legislature statutorily do that?
It's an interesting question. Technically, to change the concept of the stewardship trust would be a constitutional amendment. There might be legislative ways to come at the cat.
Thanks, and thanks for all the hard work you're about to do. I think there will be some very measurable positive benefits, actually, particularly in outreach and understanding of who we are and what we do and what constraints we have that won't.
And that is the end of our program.
That is the end, so.
Next line day tomorrow.
Being no more business and getting ramped up for tomorrow,
What's
let's adjourn this meeting.
All right.
Thank you, Commissioner Tribble, for attending.
Yes, was Archer.
Everybody?
It's HR, so that I.